Thank you. Good morning, Commissioner. It's Andrea Gonzalez, Counsel for the Government of Canada. The next witness will be Minister of Justice David Lametti. In addition to being Minister of Justice, of course, the Minister is the Attorney General of Canada, the lawyer to the Government of Canada. And I wanted to put on the record that the Government of Canada continues to assert and maintain all of its claims of solicitor-client privilege in respect of all legal advice and opinions. Minister Lametti's attendance here as a witness is not a waiver of any claims of privilege by the Government of Canada, which he has an obligation to protect. We will be objecting to, and Minister Lametti will be refusing to answer all questions that would delve into areas of solicitor-client privilege. So I just wanted to put that on the record at the front end, and hopefully examinations can be appropriately tailored to keep the objections to a minimum.
Okay, well, it will be an interesting maneuver throughout the testimony, but I'm sure everyone will be on their guard. So with that, perhaps we can swear the witness.
Minister Lametti, will you swear on a religious document or do you wish to affirm?
On a Bible, please. Thank you.
For the record, please state your full name and spell it out.
David Lametti, D-A-V-I-D, L-A-M-E-T-T-I.
Do you swear that the evidence to be given by you to this commission shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do swear.
Thank you.
Thank you.
Again, Commissioner Gordon Cameron for Commission Counsel, and good morning, Minister Lametti.
Good morning.
I will begin with some housekeeping and ask you to cast your mind back to September 6th of this year when I interviewed you along with some of my colleagues from Commission Counsel, and we prepared a summary of that interview. And for the record, in case anybody's looking for the number, it is WTS 6077. Minister Lametti, did you have an opportunity to review that summary for accuracy?
Yes, I did.
And can you confirm it's accurate and that you adopt it as part of your evidence in this proceeding?
I confirm its accuracy.
Thank you. Now, if we can begin, suppose with the basics, I think a lot of what we would describe as your position and your responsibilities are already familiar to many of the parties here. But just so that those for whom it isn't familiar and for members of the public, could you describe your office? And since I'm going to be taking you to some particulars, but also if you could give us an overview of the dual role you play as Minister of Justice and Attorney General, and just describe how that plays out in the context of the work you do in conjunction with the government and cabinet.
Thank you. They are two complicated roles, and it is an important question. As Minister of Justice, I'm a member of cabinet. I'm responsible for what one might call justice policy and the development of justice policy, the curation of the criminal code, various institutions, Human Rights Commission, for example, and other Privacy Commission, other commissions that are associated with justice policy writ large in Canada. So they fall under my purview. I do not, I'll frame that, I'll come back to that when I talk about the Attorney General role. So in that role, I'm a member of cabinet. I participate in cabinet discussions, give my opinions as would any other cabinet minister, and do the work reading my documents, but also other documents from other ministers in that regard, and giving informed opinions. The other role is Attorney General. I'm the government lawyer, also sit at the cabinet table as Attorney General, and I give legal advice to the government. I receive legal advice from time to time through the Department of Justice, which has lawyers dedicated to giving legal advice in that Attorney General role. I'm the titular head on litigation, all the litigation that the Government of Canada does. And I have a role in shaping that litigation, particularly as it approaches higher courts, courts of appeal and the Supreme Court. And again, in that role, I will give advice to the Cabinet and to the Prime Minister directly from time to time. On most pieces of legislation, for example, there will be opinions being given, although there are occasional mentions in the Justice Act of the Minister of Justice giving that role. So I will, the lines are reasonably well demarcated. They certainly are well demarcated in my mind. We've had the Anne McClellan report of a few years back, which helped in the framing of certain kinds of litigation to distinguish the roles. And certainly I would say that in all of my interactions with colleagues, including informal interactions, I will always try to be clear which hat I am wearing as I'm speaking. And if that hat changes in the course of a conversation, I will give them a flag. And so I'm well aware of that of those two roles. What I will also say, this is the part that I had bracketed out before, is unlike the Attorney General of the United States, I do not lead investigations and prosecutions. We have an independent prosecution service, and there are other rules that guide my relationship with the Director of Public Prosecutions. But that's important to remember as well.
Thank you, and thank you for referencing the report of the Honourable Anne McClellan, and I'm going to make a few references to it because I think they help. As you might remember, she had some compact and forceful ways of describing the two roles, and I'm going to ask that be put up on the screen just so that we can look at it, and I'll ask you to see if they accord with your understanding of your role. And Mr. Clerk, the document number is COM 50952. And if you can get that up on the screen, I'll ask you to go to page 6 at the top. Now, we don't need to know, for my purposes at least, Minister Lametti, the background to Anne McClellan's report, but
I know it well.
Yes, I imagine you read it very, very carefully when it came out. But she was reviewing the roles of the Attorney General and the Minister of Justice, and she had things to say about it in other contexts. But I'm just going to talk about her introductory comments, where she describes in an overview way, I think in most cases, quoting from Professor Edwards, about the roles as they're known in our constitutional system of government. So the first one, if I'm trying to get the top of page 6, Mr. Clerk, and that doesn't look like it to me. It might be that it's a different PDF number. The top says introduction. There we go. And the sentence I'll read is the second one. The Attorney General of Canada has a unique and profoundly important role. They stand at the heart of accountable government as the person responsible for defending the rule of law by ensuring that all government action is in accordance with the Constitution, including the Charter of Rights and Freedoms. And I take it from your earlier description that you would agree with her description of that part of your role.
Completely.
And then if we go over, Mr. Clerk, to page 10, if we're working with the same page numbers, it is the page that has the heading, the Attorney General of Canada. There we go. And I'll just read this historical introduction here. The sentence I wanted to concentrate on was the second one. For that reason, the Attorney General is often referred to as the Chief Law Officer of the Crown. and you're probably familiar with that phrase. Again, I think, if not invented by, certainly most written about by Professor Edwards in his work. And then 2 paragraphs down there, the paragraph that begins in their role of Chief Law Officer of the Crown, the Attorney General is not accountable to a particular government. They are required to act according to the law and the broader public interest, not according to personal or partisan interests. And again, as I understand your introductory comments, you'd agree with those observations of Anne McClellan as well?
Again, completely.
Right. And then if we can go over a page, perhaps 2 pages, Mr. Clerk, to the page that has at the top of it the Minister of Justice. And here we have the description of the other role, and we'll just do this as compactly as possible with the first sentence. Under the Department of Justice Act, the Minister of Justice is the legal advisor to the Governor General, which means in practice that they are the legal advisor to Cabinet. And again, that would accord with your understanding of your role?
That's right. I alluded to that in my opening remarks.
Thank you. I'd like to take you to some of the documents. These were produced fairly recently to us, and so they aren't organized in my papers, or at least to the extent Commission Counsel has been able to organize them relative to the way they were filed. And I know just from some emails that have come in as we've been preparing for this morning's appearance by you, other parties might have struggled with this as well. So I'll try to help parties along with the way I have organized them, at least. And the first one, Mr. Clerk, if you could call up SSM CAN 407845. And Minister Lametti, we're all going to, you and I think the people following are going to have to struggle with 2 things here. One is how one reads a text conversation when it gets printed out like this, especially when it's broken up into multiple pages. Who is speaking in which bubble as we go down? So I'll ask you to help me with that. I believe that the first bubble there, do we have a contingency? That is you speaking, am I correct there?
I believe that's right.
Okay, the date here is Sunday, January 30th, which would be, you might remember, the Sunday of the first weekend of the convoy arrival in Ottawa, correct?
That's correct.
Okay. And can you explain, by the way, if I understand it correctly, and just look down a bit, this is a text exchange you're having with Alex Steinhaus, who I believe is your Chief of Staff?
I believe so, yes.
Thank you.
I believe it's a text exchange with him. I know he's my Chief of Staff.
and if, as near as I can follow it, you're in gray and he's in blue for this page, and that gets tricky because it switches around as we go between, depending on whose phone the message is from. Anyway, if we look at the first paragraph there, do we have a contingency for these trucks to be removed tomorrow or Tuesday, open parentheses, if they were Black or Indigenous, ellipsis, close parentheses. And I was wondering if you can help explain what point you were making to your Chief of Staff when you added the parenthetical comment to the initial statement.
Certainly. Look, there is evidence of systemic racism in our justice system. It's in my mandate letter. I do my best to try to root it out with various policies. And certainly there was a legitimate criticism being leveled at police authorities with respect to that weekend, that if there had been a Black Lives Matter protest or an Indigenous protest, that perhaps the police reaction might have been different. This is a conversation between Mr. Steinhaus and myself. It's not meant to be public. Obviously, it's in a text. But I am sensitive to claims of systemic racism in our policing. I'm sensitive to systemic racism in our criminal justice system, and I'm doing my best in the areas of my purview to identify it and to weed it out.
And so if I understand that answer, the point you're making in the parenthetical comment to your chief of staff is we must approach this situation mindful of the potential for systemic racism and careful that we don't.
I would interpret it more as, are the police moving in the same way that they would be were the protesters Indigenous or Black?
That's well put. So I'll move on to the next paragraph. What normative authority do we have, or is some order needed, question mark, EA, question mark. And there's been an evolution in the language, and in particular the use of the word normative. So could you just help us with what you meant by this use there?
What kinds of laws, bylaws exist at the municipal level, at the provincial level, or at the federal level with respect to this kind of occupation, which had already, it was clear that when they didn't leave, it ceased being a protest and began being an occupation. What kind of authorities existed for the regulation or the
Okay, so we can
the safe removal of these.
If we can just put what existing authority in there, if normative is giving us pause.
I meant legal rules by the word normative. I'm an old academic.
So you're in the old school with me, okay? But the end of the sentence is interesting. EA, I'm sure, is a reference to the Emergencies Act. Right?
Absolutely.
And this is depending on how you count it, it's the second day of the first weekend, maybe the third day of the protest, if you count Friday as a day. So the second or third day of the protest, and your mind goes straight to the Emergencies Act in the first text we get produced in these proceedings. Can you explain why that came so quickly to your mind?
I was being prudent. I was being prudent.
Thank you.
I had been through the pandemic with my cabinet colleagues. It is no secret that we did discuss the Emergencies Act in the context of the pandemic, and I became quite familiar with the requirements for consultation and for the standards that would have to be met for different kinds of emergencies. And so I knew that we had to begin thinking about it, whether or not it was ever going to be an option. As was the case with the pandemic, we never actually used it. So it's something that I prudently raised there's a question mark there, as you see, something I'm prudently raising with my chief of staff to begin thinking about, to get the department to begin thinking about, in case we need it. Because the worst scenario would be something explodes and we are not ready to use it because we haven't done the kinds of consultations necessary or asked the appropriate questions to the appropriate people in order to get it done. So this is me being prudent, and it's based on my experience and the work that I put in during the pandemic, again, with the Emergencies Act and the possibility of using it in that context.
That's helpful, thank you. And we'll go to another one of these texts next. This is, Mr. Clerk, the one with the same preceding numbers, but the last four digits, 7850. Now, again, trying to follow the bubbles here, the blue is now you or Mr. Steinhaus?
I don't believe it's me because I'm generally required to go to what's called a MINDM, which is a ministerial, deputy ministerial meeting. So if anyone's missing the meeting, it's not me.
Right, and I think actually the first bubble there doesn't sound like you talking. It sounds like someone talking to you about what your deputy has told you, that you're being invited to a meeting about the convoy, and if it matters, we can look at the PCO's chronology to confirm that there was indeed a briefing on the convoy on that date. But the part that interests me here is your chief of staff in the second bubble says, and here he's talking, before you were talking about your initial thoughts on first encountering the convoy, we're now at Wednesday, February 2nd, so fourth, fifth day perhaps in. But
I apologize for interrupting.
Sorry?
But it's February the 4th where those bubbles appear, not Wednesday the 2nd.
Sorry, thank you, yes. Friday, February 4th, and the comment your chief of staff makes is, I believe the angle is incoming the Emergencies Act. Now, we'll have to, can you help us with incoming, or does it just mean what we would infer it as a sort of slang way of saying the introduction of, or the...
I would say the preparatory work for,
right,
is what I understood by that. And certainly in the context of the previous bubble, but also in the context of other discussions. It was about preparing for the possibility, not preparing in any way for the introduction of the act, but rather doing our due diligence as lawyers within the Justice Department and in our ministry in order to make sure that if we were to use it, we would be prepared.
Understood, and that's helpful. Thank you. And do you recollect the meeting and what was discussed at it?
You're going to have to help me with the dates. It could be referring to the SSE committee. I believe at that point that's what it would be. It could have been a cabinet meeting. I'm not certain. You'll have to help me with the dates.
Well, if it sounds a bit early for an SS meeting to me, but I guess the point is that as near as you can recollect, it is exactly as you described it, a meeting to get ready.
Yeah, there's no. I don't believe there's an extraordinary meeting yet, and so this is really about being ready for all eventualities.
Okay. The next text I'd like to take you to is really leading up to a discussion about how you and Minister of Public Safety, Marco Mendicino, talked about the situation that Ottawa was facing and to some extent the country was facing, even at this early date. And so, Mr. Clerk, if you could turn up the document that is the same prefix but with the number 7852. And if I'm reading the dates correctly, we are still on Friday, February 4th, as in the last exchange, but though that was with your chief of staff, I think. This, if I'm understanding correctly, and you can confirm this for me, please, is an exchange between you and Minister Mendicino?
I certainly believe it is. I certainly recognize my words there, but I believe the other would be Minister Mendicino, but I'm not 100% certain.
And which words do you claim?
I claim the green.
Okay. So Minister Mendicino says to you, the police have all the legal authority they need to enforce the law. They just need to exercise it and do their job. You might, if you've been following the evidence of Minister Blair and others who made similar comments?
Loosely, we do have other work to do while we're here.
Understood. And then you make a comment, again, perhaps not unique to yourself, but expressed very, very frankly here. I was stunned by the lack of a multi-layered plan. Now, we've heard other expressions like contingency plan, but not multi-layered. Can you, are they the same thing? Is that what you mean here?
I don't believe so. I believe it's a structured plan in stages to get protesters to leave peacefully, get occupiers to leave peacefully, and if not peacefully, begin to move them out in an orderly fashion, in a safe fashion. So there are different layers to that.
Understood. So if I'll just interrupt you to see if I can anticipate what you're going to say. You're actually thinking of a plan to deal with the protest by February 4th. You're stunned by the absence of a plan.
Right. And this is referring to local police, the police of jurisdiction.
The Ottawa police not having a plan.
That's correct.
By that Friday. And you make again in stark terms the observation, slowly is incompetent. And the words speak for themselves, but was that an observation you were making specific to the situation you were looking at, or was that an opinion that you had developed from some other?
I'm a part-time resident of Ottawa. I was a part-time resident of Ottawa during this. I was forced out of my living arrangements in Ottawa because I felt the place I was living was unsafe given the protests. So I spent part of my time elsewhere in Ottawa, and I spent part of my time in Montreal in order to escape Ottawa. So I was frustrated, I have to admit. This is a complete product of the heat of the moment. It is frank. I think I would soften it now with the benefit of hindsight with respect to the former Ottawa Chief of Police. But it reflects, I think, the fact that my life had been altered by this. My staff was being harassed when they went into work by convoy members who took issue with them wearing masks, particularly my female staff members on my ministerial team. And I was quite frustrated, I will admit.
Thank you for that. Now, for a second, I'd like us to revert to the comments we talked about at the beginning, where your role was described as, and you acknowledged as being, the chief law officer of the Crown in your capacity as Attorney General, and effectively Cabinet's lawyer in your capacity as Minister of Justice. And is it fair to say that you would expect your Cabinet colleagues to place considerable weight on your views of the legal issues that were facing the government as it encountered the convoy, the protests, and indeed the policing situation that you just opined on in your note about Chief Slowly?
In these kinds of interactions, I'm interacting, first of all, with a colleague and a friend. So there will be banter. There will be occasional attempts at bad humor on both of our parts, and with others as well. And there will be occasional moments of frustration, which you've seen here. I'm speaking here more as a Cabinet colleague, as a minister. I'm not speaking as Attorney General. I will guard my comments when I'm giving legal advice to my Cabinet colleagues, and I do that often. In general, I think it's fair to say that when I'm interacting on text messaging with my colleagues, I'm acting as one of their contemporaries as a minister.
Okay, well, let's see how that plays out if with respect to the particular point that has come under discussion by a number of senior officials, a number of police officials, indeed the two witnesses at least who've preceded you, Minister Mendicino and Minister Blair, and that is the line between, I think it was perhaps First Commissioner Lucky who called it the line between church and state, but it's generally understood as the appropriate role for governance or oversight of police forces, and that it not tread too far into the realm of directing the police and their activities. So that is I take it, that is a topic on which you, as the Attorney General of the country, would have and would be expected by your colleagues to have fairly well-developed views. Is that fair?
Absolutely. And you'll see that in these exchanges, I'm in no way saying we need to direct the police. Well, the Ipperwash inquiry was clear in that regard, although we can identify as a government, according to that inquiry, priorities for us, but we can in no way make operational decisions for police of jurisdiction.
Well, let's look at these texts, and we'll come back to exactly that question of where you were relative to the line. Mr. Clerk, could we call up 7851? Again, same prefix, but with the last four letters, 7851. The date, if I'm following this correctly, is February 2nd, so the Wednesday of the first week of the convoy's presence in Ottawa. And again, if I'm following the bubbles correctly, you are having a text conversation with Minister Mendicino, and you are in blue and he is in gray. Have I got that right?
That's correct.
Yeah. And the comment you make at the top of the first bubble, and again, though we'll take your caveat that you are texting here and not submitting a memo to Minister Mendicino, you're sending him a text, but time is short, events are unfolding quickly, and you are entering into, if not already, in a crisis situation. And your first comment is you, Marco, need to get the police to move, right? And then if we look at another text, and again, I apologize for the way these are just not filed in order, so I have to go through various documents. The next one I want to talk to you about is, Mr. Clerk, it is, again, same prefix, 7854. So we're going to go from you need to get the police to move. And again, this is the Attorney General of Canada talking to the Minister of Public Safety of Canada. Now, at this time, I think you're aware, but correct me if I'm wrong, Minister Lametti, that Minister Mendicino has become, in effect, the interface between the federal government and the City of Ottawa, the mayor, and the OPS, correct?
I believe so, and I would add I spoke to the province of Ontario as well.
Yes, but here you're speaking to the Minister of Public Safety, whom you know is the government's interface with the Ottawa force and city, and you say to him...
Actually, that I'm not going to accept that. I know that he is interacting with Minister Blair, and I presume at this stage that Brenda Lucky is having a role in these interactions. So I'm in no way certain that he is directly interacting with the OPS. I know that he's interacting with the Ontario government. I know that he's interacting with Minister Blair and Minister Lucky, but it's not a fair presumption to say that I know he's got direct.
You might not have known it if I reminded you that he actually had a discussion with the mayor the mayor of Ottawa, in respect of additional resources being provided by the federal government, and confirmed to cabinet that he had authorized that.
With political actors, yes.
Yes.
I knew he was having those relationships, but you had mentioned the OPS, and that's quite different.
Thank you, and that's a fair qualification. But with that in mind, again, the Attorney General speaking to the Minister of Public Safety, who is the liaison to the Mayor of Ottawa, and this is what you say at the bottom of this text. If you just scroll down a bit more, thank you. Spoke to Doug Downey, and here again, you are speaking these words to Minister Mendicino: needs slowly to be quick, quick, quick. Now, I guess the question I would pose is this: do you think that the question of whether Chief Slowly should be dealing with the Ottawa protesters quick, 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 or wait until he believes he has the resources to perform the operation safely? Do you think the decision between those two options is an operational decision for Chief Slowly, or a decision that should be influenced by you and Minister Mendicino?
It's definitely an operational decision. Remember, I'm interacting here as a colleague and Minister of Justice around the cabinet table. I'm not interacting as Attorney General. Minister Mendicino and I have a close relationship. There's some banter here. There's some humor here. That's a reference to my favorite Christmas movie, the quick part. And so I think we could take the temperature down here. We as a government, according to the IPRWASH report, can identify our priorities to police services. That's the role that a Minister of Public Safety has, in this case, possibly also the Minister of Emergency Preparedness. But we can't make operational decisions. We know that. And remember, I'm not the one interacting with the police. And I'm assuming that Minister Mendicino is working with cabinet colleagues on a level of principle.
And happily for the point that you've just made, Minister Lametti, you do get sort of airtime for that point in the texts that were filed. And so I'll ask the clerk to call up same prefix 7853. And I believe this is an extract of a text between you and Doug Downey. Is that right?
That's correct.
Can you remind us who Doug Downey is?
He's the Attorney General for Ontario.
Okay. And the words that are on the screen read for themselves. That's the second bubble that I'm interested in. And I think at the end of the second bubble, you make roughly the point that you were just making to me unprompted. You say, we can't make operational decisions, but Solgen can make government priorities clear in these situations as per IPRWASH report. And so I'm going to, I think you've made the point already, and I just wanted to, in fairness to you, point out that you'd indeed been adopting that position at the time in your own words. Although maybe, even though this is a text, we'll elevate them to the level of seriousness because you've actually incorporated reference to a Commission of Inquiry report. And
this is also a different conversation with a counterpart in Ontario,
right,
with whom I have a very productive working relationship. But this is not the banter that one has between friends with the same sense of humor. Understood.
And on that point, we've heard from a couple of your colleagues and a number of senior officials, including police officials at all levels of government, in police at the RCMP, OPP, and municipal levels, about this question of the topics discussed in the IPRWASH report, in Justice Linden's report, and in the Morden report with respect to the G20 protests in Toronto. And your colleagues who've spoken before you have expressed an opinion on this very point you make here in your text. We can't make operational decisions, but Solgen can make government priorities clear in these situations as per IPRWASH report. Now, I think the commissioners set the precedent here that I have to give spoiler alerts in fairness to you, that this question was put by me to Minister Blair about whether it would be appropriate in the case of competing problems in different parts of the province, say, if it would be appropriate for government or the Solicitor General in Ontario to advise the Commissioner of the OPP, if we take that jurisdiction, though presumably it could also apply in other contexts, to advise the Commissioner that among the two public order situations facing the province, the government of the day, or the Solicitor General in particular, considers City X to be the priority situation. The example might be as between Ottawa and Windsor. Windsor is causing huge impacts on the national economy, and so the province considers that the priority objective for public order, getting public order back under control, leaving it to the police to decide if they want to do anything about that input, and if so, how they would do about it. They might decide that they can't address that priority expression, but the question is it fair that that priority be perhaps even appropriate and necessary, that priority be expressed to the police? And Minister Blair seemed to think not, that would be going too far even to express a priority. I think we're seeing from your text here that you're going to differ, but again, spoiler alert, Minister Mendocino also had a view on it, though I think his view covered the spectrum from all the way at no to all the way at yes, depending on which part of his answer you focused on. So you don't have to worry about disagreeing with him. So what would you say about that scenario where there are competing priorities, and put it at the federal level if that's something that you can identify with more appropriately, where the federal government is facing public order issues, perhaps not public order, perhaps environmental issues that have caused the need for policing resources, but in one way or another, and a view is expressed or could be expressed by the government about its priorities. Do you think that would be appropriate to communicate that to the police of jurisdiction?
In all cases. I mean, I think I'm probably, in most contexts, probably closer to Minister Blair in the answer that I'm going to give, although there will be some contexts where I might move towards a more flexible answer. In all cases, the operational decisions will be made by the police of jurisdiction, in all cases. What I was referring to in the Ipperwash report, and what the Ipperwash report was referring to, that it is legitimate for a government to say, we have an important public security situation here, we need to have something done about it. And then it ends there, right? Then it's up to the police of jurisdiction to take care of it. The scenario that you have given me is forcing me to choose or to articulate my priority as, in this case, a member of the federal government, to say we need something done in X place or Y place. And I think the inference in your question is that there may be a different priority elsewhere.
That's a premise of the question, not just an inference.
It's always going to be, first of all, the Solicitor General of Ontario in the jurisdiction that we're talking about right now, who is going to articulate that priority. And then again, the operational decisions will be made by the police. So we're an input into that decision-making process in the province. So I'm probably closer to Minister Blair on that. Although there will be, I believe, situations where we may have to say as a federal government, look, something is quite urgently happening here. We urge you to do something. And in all cases, it depends on the police of jurisdiction to make operational decisions.
Again, to be fair, there were parts of Mr. Blair's answer where one could draw the inference that the police of jurisdiction and the police who might be able to help from out of jurisdiction would have welcomed some input on this point. For example, you might imagine the OPP saying, we've got lots of public order units. We can deploy them where the government considers it most appropriate. Operationally, they're roughly equivalent to us. What is your priority? Help us decide. If you got that type of request, it sounds to me like you'd feel comfortable answering the question.
I guess what I would say is I would commend everyone to read the Ipperwash report, quite frankly, because it's nuanced and tries to deal with the variety of these kinds of situations.
Well, we're hoping that the Commissioner might be able to add something to the Ipperwash report by his observations on the events here. So we'd really benefit from more than just punt to Ipperwash. If you could give some...
Well, I'll be honest with you, it's hard for me to answer hypothetical questions. I am suggesting to my colleagues that we make our priorities known to the Solicitor General of Ontario in a situation where a number of people felt Ottawa was being neglected with respect to the occupation that was happening on Parliament Hill. I'd rather, to be honest, as a prudent Attorney General, I would rather avoid giving public legal opinions on hypothetical situations. But the nuance is there in the report. There isn't, I believe, a black or white answer other than to say that operational decisions will always be made by the police of jurisdiction. The identification of priorities is a much more complex matter.
Okay, thank you for that. I'm going to take you to another series of texts, and this does get messy, so I'm not going to bother with a whole bunch of document numbers. I'm just going to read these in, Mr. Commissioner, and if parties want to try to follow, just because I figured out the sequence of them and it helps follow there's a series of texts between you, Minister Lametti, and your Chief of Staff, and you have to jump back and forth between his set of texts and yours to get the sequence right. So I won't ask you, Mr. Clerk, to call these all up. I'm just going to read them in, and then I'll ask you if you can remember what I'm talking about, Minister Lametti. They are 7861, then 7864, then 7863, then 7860. And that takes us through a series of texts between you and your Chief of Staff.
Counsel, do you mind if I see them? This is going to be very difficult for me to...
That's a fair point, but
Okay.
certainly the first one, and because I think that will twig what we're talking about here. Mr. Clerk, could you call up 7861? Now, it's the morning of Sunday the 13th, so this is leading up to the IRG meeting at which serious consideration is going to be given and ultimately conclude with the decision being given ad referendum to the Prime Minister. Am I correct that you're in the gray there? Have I got the...
Yes, it is.
Right. So you observe that we, by which I assume you mean the government, are on an inexorable march to the EA, not enough happening in Windsor. And then I will, just again to help you, because I can appreciate that you want to be accurate on this, just I'll mention that this is a series of texts in which you are anxious to know the status of two things: whether the Windsor Bridge, the Ambassador Bridge, is getting cleared, and whether the plan, the Ottawa police plan to clear the city of the protesters, is coming to maturity. And you appear to want, in this morning of the 13th, the most up-to-date information you can get on those 2 points. So, Mr. Clerk, if you
I can see the first point. I'll wait on the second, but let's
see. We'll skip ahead to 7863, Mr. Clerk, if you can bring that up, because there you state it quite clearly. And just scroll down to the thanks, Alex. Take a second to read that to Minister.
Okay.
And do you take? Do you understand now what I was talking about? Am I correct to say you are anxious to get as the most up-to-date and clearest information you can on those 2 points?
That's right. And I'm giving my Chief of Staff a heads up that this is what I will be asking at a meeting. Cabinet meeting later. So I'm asking him to send out appropriate feelers to people who can answer this question so that we can have the most up-to-date information at a meeting that I'm going to participate in.
Fair enough. And I take it that's because the status of these 2 points will be at least among the most important points you will want to brief the IRG on, or at least be competent to talk to the IRG about when you have your meeting?
It's more that I want the people at the IRG to be able to answer those questions.
I see.
It bears repeating that this is a rapidly evolving situation with imperfect information. It's an unprecedented situation. And we are all doing our best to try to get the information that we need to make appropriate decisions under the circumstances. And I think this is what I'm doing. I work closely with my chief of staff in that regard and other members of my team and other members around the cabinet table in order to do that.
Thank you. In the interest of time, I'm going to move on to another topic. And thank you very much for helping us understand those texts, because they, as you can appreciate, when you see just the little snippets like that, it's hard to understand the context, and you've been very helpful in giving that to us.
Is this a good time to take the morning break? Or?
Yes, indeed, it would be perfect, Mr. Commissioner.
Okay, so we'll take 15 minutes.
Merci.
Thank you.
The commission is in recess for 15 minutes. La commission est levée pour 15 minutes. The commission is reconvened. La commission reprend.
Thank you, Mr. Commissioner. I'll resume the questioning. Just before I move to my new topic, I think it would be a good time just to put on the record, and by all means, Minister Lametti, I'm going to put the Ipperwash report on the record. If it occurs to you to make any reference to it, please feel free. But that would be COM 50828. I don't need it called up, Mr. Clerk, unless the Minister wants to make reference to it. But we'll just put it on the record so it's there in case any other, so that it's an exhibit on this examination in case any other party wants to have access to it. Now, Minister, history that you and I lived through in our early law careers, and that was the invention or the development of the CSIS Act out of the MacDonald Commission report in the early 80s. If you weren't familiar with that before you took your current role, you're probably pretty familiar with it by now, correct?
That's true.
And you're aware that the CSIS Act was born out of a very long Royal Commission of Inquiry, and longer, I think, in its product than even this commission will be able to produce in terms of the volume and scope of its recommendations, one of which was the invention of Canada's first secret intelligence agency, first national security agency as an independent entity. You remember that, and the evolution through the MacDonald Commission report, and then a separate Senate inquiry into even further restrictions on the scope of CSIS powers, and the ultimate emergence in 1984 of the CSIS Act.
To be honest, it's vague, but you are reminding me.
Have you. And I think you'll either remember at the time or you'll have learned since that the reason the CSIS Act was so highly contentious, and indeed, I'll just make a parenthetical comment here. We heard a comment by the CCLA, or the Canadian Civil Liberties Association, that they were instrumental in the evolution of the Emergencies Act, and as a matter of fact, they were probably as or more active in the development of the CSIS Act, and Alan Borovoy was their lead counsel for the input to the MacDonald Commission. And the reason that he was there, and the reason people were so concerned, was that it is the development of a secret intelligence agency in a democracy is something that Parliament wants to do very carefully, right?
I think that's fair. I remember Mr. Borovoy's work, although I must admit I was following the Charter and the creation of the Charter more closely than I was following this.
Fair enough. The points of contention, even if you weren't following it at the time, you can see from the terms of the Act now, one of the major points of contention was to make sure that the scope of investigation that CSIS was permitted to engage in would be very tightly defined, right?
I can only base, I'll take your word. I can only base what I see in the Act and the rules of thumb that we see from people from CSIS who have testified. So I think that's right.
Right. Now then, along came, a few years later, Parliament and its interest in another new development, and that was the creation of a new Emergencies Act to replace the War Measures Act. And you'll agree with me that again, Parliament was faced with the challenge that it was about to create, in this case, a power rather than an institution, that had to be treated very carefully in a constitutional democracy, right? That is the power that the Emergencies Act would give to Cabinet to create extraordinary authorities in advance of their approval by Parliament, right?
I think that's right. The potential power was great and therefore seen to be very serious.
And you'll agree with me that Parliament could have gone pretty much anywhere it wanted to find the threshold that it thought appropriate before Cabinet was able to exercise that power.
Certainly.
And what it went to, we now know, was the CSIS Act, where they had just had a similar situation of wanting to make sure that extraordinary powers were appropriately controlled, right?
I think that's fair.
Okay. And the way they did that in the Emergencies Act was to make part of the threshold for the declaration of a public order emergency the existence of a threat to the security of Canada, as that term is defined in the CSIS Act, right?
That's correct.
Okay. And indeed, the thing don't know how much of we've all become, to the extent we weren't experts on the Emergencies Act before, we've all had a very fast education of it in this hearing process, and probably you know more about it now than you did a couple of years ago. But one thing we've learned is that when Parliament enacted the Emergencies Act, they didn't simply repeat the definition. They didn't extract it and reprint it in the Emergencies Act. They actually stipulated that in the Emergencies Act, the expression threat to the security of Canada has the meaning assigned to it by the CSIS Act, correct?
That's correct. It's an incorporation by reference.
Right. And we've tried to find compact ways, just for the purposes of these examinations, to describe the relevant part for a public order disturbance as it's typically likely to arise in the case of a declaration of a public order emergency, of a compact way of describing the subsection C of the definition of threat to the security of Canada, sometimes called the terrorism section, or it's the section that you're probably now as familiar as the rest of us with, that talks about activities directed towards, in support of, a threat of, et cetera, serious violence, and I'm going to paraphrase here, with an ideological, religious, et cetera, motivation. So they, in effect, said that in addition to whatever, I'll call them downstream requirements, one might have to also find, Cabinet might also have to find, the starting point would be a threat to the security of the Canada as that expression is with the meaning assigned to that expression in the CSIS Act, correct?
I think that's right, but it is only the starting point.
Right, and the starting point, assuming you get there, is you add on to that the features of the situation facing Cabinet that cause it to be a national emergency and not just an isolated threat to the security of Canada.
Yeah, do you mind if I just interject 1 minute? What Parliament did not do with the creation of the Emergencies Act was delegate the decision-making to CSIS. So there's an incorporation by reference, to the standard that's contained, the definition that's contained in the CSIS Act. So there's a conveyance of the magnitude, if you will, or the seriousness of the standard or the threshold. But they did not delegate the decision making. And again, I'm speaking here as a jurist. I'm not speaking in any way as the Attorney General giving advice to the government. I'm just giving my own opinion.
Fully understood, and we appreciate the input.
So I'm just drawing my own inferences here. But there's a magnitude or a seriousness conveyed in that. But the decision-making power is always in the hands of Cabinet, in the Governor and Council in the Emergencies Act, as well as other framing provisions that need to happen for the invocation of a national emergency. So there is a definition that is incorporated by reference. It's moved into the Emergencies Act, and the decision-making power remains with Cabinet. So there's also a purpose change. I mean, what CSIS is doing is determining whether a threshold is met for the purposes of further investigations, generally clandestine, according to CSIS protocols, with warrants, et cetera. They're all, you've heard testimony already from the CSIS director as well as Madame Tessier about the rules of thumb that CSIS uses for proceeding in their analysis under Section 2. That isn't incorporated in here because the decision maker is different. And the inputs can be much wider, have to be much wider when you're a member of Cabinet, when you're making a decision, Governor and Council. There are other inputs that can go into the meeting of that definitional standard that CSIS wouldn't normally use. And so that's very, very important to underline, that it is, while it is the same standard of the same magnitude, the interpretation of that standard is being done according to a wider set of criteria by a very different set of people with a different goal in mind, and that goal is given by the Emergencies Act and not the CSIS Act.
Okay, I want to back you up a little bit. You're familiar, I think, probably from your academic work as well as your work as a lawyer with a straw man argument.
I am indeed.
Try
not to make them, but go right ahead.
Has anybody suggested that the Emergencies Act delegates to CSIS the decision as to whether Cabinet can invoke the Emergencies Act or declare a public order emergency?
Well, I'm sorry, I just want to be clear. When you say has anybody suggested, we have to be concerned about Cabinet confidence as well as solicitor-client privilege. So when you say anybody, it would be helpful if you specify who you're asking about.
Has anybody who's a party to this proceeding, let me put it that way, advanced the argument you just purported to debunk that Parliament had delegated the decision to invoke the Emergencies Act to CSIS?
Even if delegation is one end of the extreme, but even using the same standard or purporting that it be the same standard that is contained, the actual substantive standard that's contained in the CSIS Act is effectively doing the same thing.
The substantive standard contained in the CSIS Act is the one that Parliament said is assigned to the meaning of that standard in the Emergencies Act. That's not CSIS. That's not Cabinet. That's Parliament, what it did in 1985, right?
No, not exactly, because there's been evolution of the Act. You've heard from CSIS how they interpret that provision. And it's markedly different in terms of the goals that CSIS has in order to investigate Canadians and others on Canadian soil. And so there's a very serious, and you pointed it out yourself, sir, in the preparatory statements that you made about the CSIS Act and citing Mr. Borovoy. There's a very serious matter going on here when we are allowing a Canadian agency to investigate Canadians on Canadian soil. It is, and the rules of thumb that they have developed since that time are very, very different, I think, I would suggest, than the kind of decision that we had to make under the Emergencies Act. And I would suggest That proper rules of statutory interpretation gets me to this conclusion.
For a second there, I thought you were arguing my case because you were trying to tell me how important the threshold was in the CSIS Act before Parliament would let a secret intelligence agency investigate Canadians in a democracy.
That's right.
We totally agree on that. And then a few years later, Parliament adopted that definition as the threshold for the invocation of the Act. It said the very same threshold, right?
The threshold as applied, as you've seen in testimony before this commission, has evolved. The rules of thumb for interpreting that have evolved. The purpose of that act is very different. So while the words were incorporated, and I have put to you, the magnitude of importance was conveyed, and the kind of threat was conveyed. Given a different decision maker, given a broader set of inputs, the very same words will have not a wider meaning, but will have a wider area of interpretation according to the very structure of the Emergencies Act. And I think that is the interpretation that I would put to you as the one that best bears out in practice and is correct.
Let me see if I can approach it this way. Again, just as we all, I won't ask you opinions on legal matters. I just want to see if you agree with me for the purposes of this discussion that what Section 16 of the Emergencies Act, 16 and 17 require is what lawyers sometimes refer to as a combined subjective and objective test. That is, Cabinet has to have had a belief that the threshold was met, that there was a threat to the security of Canada, and that belief has to have been on reasonable grounds, right?
That's correct.
Mr. Commissioner, I am concerned that we're going down the road of arguing the case. Minister Lametti is here as a fact witness. There will be a stage to come after this evidentiary portion of the hearing where legal arguments are submitted. The Government of Canada will be submitting detailed legal arguments, and I am concerned that having Minister Lametti on the stand is not the opportunity to be arguing the case.
Mr. Commissioner, I think I can approach it in a way that addresses my friend's concern, though to his credit, Minister Lametti was fully able to answer my question and answered it the way I'd have expected him to. But to address my friend's concern, I'll simply read Section 17 of the Act to him and then use that as a preface for my point. When the Governor in Council believes, and we'll just stop here to say that if we speak compactly and effectively, we're talking about when Cabinet believes. Can we work with that premise? Yes, you're nodding.
That's fine.
Thanks. When the Governor in Council believes on reasonable grounds that a public order emergency exists. So this is why I say that lawyers, especially so highly qualified lawyers as you, see that the Governor and Council has to believe, doesn't just have to have reasonable grounds, it has to believe, and that belief has to be on reasonable grounds. So it's, now, mind you, I don't want to, if this is pushing the level where you're comfortable talking about it, but that you can see that those are two additive things. One, they have to have believed it, and that belief has to have been on reasonable grounds, and I'm just reading the words of the Act. Can you follow me that far?
I can indeed.
Okay. And then the other thing that the Act requires in Section 58 is, and again, I'm not asking for opinions. I'm just going to read the Act to the Minister, that you file what we call the Section 58 explanation, and it's all over the place in the record of this proceeding. And that has, and I'm just reading from the Act, an explanation of the reasons for issuing the declaration, right? So would you agree with me this far? What your Section 58 explanation has in it are the grounds upon which Cabinet formed its reasonable belief that a public order emergency existed, right?
That's correct.
Okay. Now, if you were asked to, could you, sorry, I'm going to back up a little further. The Section 58 explanation, that is that's not an ex post facto justification of the invocation, is it? The Act says that it is to stipulate the reasons that the emergency was in fact declared, right?
That's correct.
Okay. And that Section 58 explanation then is where the Commission and the parties, to the extent they're exploring the issue, can find all of the facts on which Cabinet relied to come to its conclusion that it had reasonable grounds to believe, that it had formed a belief and that that belief was on reasonable grounds, correct?
The facts, yes.
Okay. Now that Section 58 explanation is going to include other material, isn't it? Because it's going to include the material on which, because the threat to the security of Canada is the starting point, and then what arises from, again, to use the words of the Act, the threat to the security of Canada is an emergency of such a scope that it's a national emergency. Again, I'm just trying to follow the framework of the Act. I'm not asking for opinions, but as I'm saying, that's why there'll be more in the Section 58 explanation than just the threat to the security of Canada, right?
It is true that there is more in that Section 58 discussion.
And probably in the Section 58 explanation, you would have included the reasons why existing authorities weren't adequate to deal with the situation, correct?
Now you're pushing me to an area where this may or may not have been covered by a legal opinion, or you're pushing me to a point where I'm going to rely on solicitor-client privilege.
Oh, okay.
I'll leave the argument to be made by our lawyers.
I'll just see if I can. See if I can move you a bit by taking you back to Section 58 of the Act. It is in your Section 58 explanation that you are supposed to have the reasons for issuing the declaration. So I was just following through the three things that one might expect to find in a Section 58 explanation. The grounds for the threat to security of Canada, the reasons that arising out of that threat, we had a national emergency, and the reasons why existing authorities were inadequate or insufficient to deal with it. I'm not trying to be technical here, but those would be the three topic areas. If you're not comfortable going along with me there, what I'm just trying to find. I'm
actually not comfortable. I'm not sure I accept the premise of your organization of the Section 58 itself. I'm not sure. I don't believe you've had experience drafting one. I think this was the first time. So I think what is important is what is in Section 58, which are the facts upon which the Governor and Council based its decision. And for the rest, the legal argument and the legal interpretation, I will leave that to my lawyers and rely on solicitor-client privilege.
Okay. Is that because you consider it too subtle or complicated? Because the Act sort of lays it out so formulaically about the process by which Cabinet comes to this decision, finds a threat to security of Canada, out of which or from which arises a national emergency, and existing authorities are inadequate. That's sort of exactly what you'd expect. And frankly, when you read your Section 58 explanation, that looks like what you're trying to do. So I'm pausing by if there's some way we can move ahead with this that you're more comfortable with.
I think the Section 58 text speaks for itself, that we were, as the law requires, we put out the reasons for which we arrived at the conclusions we arrived at, and the conclusions are there. As for the process that got us to those conclusions, I'm going to leave that to the final argument of my lawyers. That pushes me into an area where I can't really answer the question without infringing on solicitor-client privilege. So you're putting me in an awkward position, and I'm going to have to rely on that privilege.
And I'm going to respect your decision to rely on it. What I'm going to ask you is a factual question in a sense. Presumably, you could have by now, or you could in final submissions, or one could, the parties could, identify in the Section 58 explanation those facts on which Cabinet relied to conclude that there was a threat to the security of Canada.
In addition to this proceeding, there are other legal proceedings upon judicial review, for example. So it would be derelict of my duties as Attorney General to pronounce on that here. I'm going to let lawyers in each particular context, whether it be here or whether it be in those other proceedings, I'm going to let them do that as they should.
And I hope my question didn't ask you to go as far as actually doing it. What I was asking you was if you could confirm that it should be possible for your counsel, frankly, could have been possible before we started this whole thing, but it's at least possible now, for them to go into the Section 58 explanation and tell the Commissioner, perhaps in their final submissions, where in that Section 58 explanation one finds the grounds on which Cabinet formed its reasonable belief that there was a threat to the security of Canada.
Mr. Commissioner, the Section 58 report, it's in the record. It certainly will feature in closing submissions. I'm not sure there's much to be done about what is or isn't in the report. It speaks for itself.
Okay, but can we at least agree on this, Minister? If there are, or to the extent there were, to the extent Cabinet did have reasonable grounds to believe that there was a threat to the security of Canada, the Commission will find them in that Section 58 explanation, right?
The Commission will find the factual basis for it in the Section 58 report. The factual basis will be in the Section 58 report, and that is outlined there.
Thank you. And with that answer, which was helpful, thank you, Minister. With that answer, Commissioner, I will end my examination of the witness.
Okay. So thank you. We can now go to the next phase, the cross-examinations. First are the convoy organizers, please.
Morning, sir.
Good morning.
For the record, my name is Brendan Miller. I'm counsel to Freedom Corp, which is the entity representing the protesters that were in Ottawa in January and February.
Good to meet you.
2022. First, Professor Lametti, it's actually an honor to meet you. I've used some of your articles in my litigation practice, so I'm a fan. In any event, sir, we'll just get right into this. As the Attorney General and the Minister of Justice, your powers and duties come from the Department of Justice Act. That's correct?
And in part the common law, so the Department of Justice Act in particular with respect to the formal roles.
Right. And under Section 4 of that Act, your powers and duties include that you shall see that the administration of public affairs is in accordance with the law. Is that correct?
That's correct.
And under B, it also has you as the superintendents of all matters coming within the administrative justice federally. Is that fair?
That's fair. There are nuances in terms of how that plays out, but yes, that's fair.
And then under Section 5B, you shall have the regulation and conduct of all litigation for or against the Crown or any department. Is that right?
That's correct.
And that, of course, includes the Department of Justice, including the legal team here today.
Indeed, it does.
Yes. And you might have, I'm sure you've got it, that in a ruling yesterday, Commissioner Rouleau ruled that the Department of Justice nor the parties were able to produce any legal authorities for the GOJ to redact records on the basis of parliamentary privilege. Are you aware of that?
I'm not particularly aware of that. Normally, the parliamentary privilege is dealt with by others, such as the clerk, and that's an ongoing discussion. So I'm not aware of the particulars of that rule.
So what Justice Rouleau ruled was that there's just no authority for redacting documents on the basis of a parliamentary privilege. So I'm wondering if under your powers, under Section 5 sub D of the Department of Justice Act, if you can direct that the Department of Justice release all the records that they've provided in this proceeding with the redactions for parliamentary privilege unredacted.
Mr. Commissioner, I don't think that's an appropriate question. It doesn't suit the purposes, fall within the purposes for which Minister Lametti is here to testify. My friend is well aware that you have made a ruling, and this is something to be dealt with through the normal commission processes and not through a witness.
Very well. And from being a lawyer and a law professor and attorney general, I take it you have an intimate understanding of solicitor-client privilege. Is that correct?
A reasonably good one, yes.
And of course, you also have an understanding of Section 39 of the Cabinet Evidence Act and Cabinet Confidence. Is that fair?
Again, a reasonably good understanding.
Now, one of the documents produced by DOJ in the record, and I'm assuming it was just produced to prove it was done, is the redacted legal opinion. It's just the document itself that was given to Cabinet. It's fully redacted. But of course, you agree that Cabinet received a legal opinion about the Emergencies Act. Is that fair?
I
Mr.
will not
Commissioner,
confirm or
I'm going to object to this question. It gets into areas of solicitor-client privilege.
Okay. Now, we have evidence in this proceeding from the Privy Council Office and Ms. Jody Thomas that the Government of Canada's position is that, of course, as you said, that Section 2 of the CSIS Act has a different meaning and that it has a different scope based in its reference in the Emergencies Act. That's right?
I will neither confirm nor deny that. I spoke giving an opinion based on the
Right.
text of the Act. That is, as I was careful to point out at the time, that was neither a waiver nor a confirmation of any advice that was given based on that text and based on the facts that were given. I took great care to not link the two. And I have no comment on what Ms. Thomas said. I will leave that to our lawyers to discuss in final argument.
Right. And but you've testified to the same thing, that you're going to leave it to counsel. And I take it that as a lawyer in preparing for your testimony here today, you reviewed all the relevant records and documents that you had access to and in your possession and power to obtain. Fair?
I reviewed documents, yes.
Yeah. In the record and the proceedings and the documents that you reviewed, and the ones that we have available unredacted, can you point to me of a document, of a record in this proceeding that existed prior to the invocation of the Emergencies Act, where there's any recording whatsoever or discussion that there is a broader scope of Section 2 of the CSIS Act when it is applied to the Emergencies Act? Can you point me to a document that says that?
Mr.
Again.
Commissioner, I think that's an inappropriate question. There are thousands and thousands of documents in the record. It's unfair to the witness.
I'll then narrow it down. Was there any such document that you reviewed in preparing for your testimony here today that existed prior to the invocation of the Emergencies Act, that it was discussed, that isn't subject to solicitor-client privilege, that it was discussed that there was a broader scope of Section 2 as it applied in the Evidence Act?
Once again, that's a question that's asking me to effectively divulge legal arguments. I remind my learned friend that it is very odd to put a lawyer on the stand. I'm really here as a cabinet minister in order to speak to facts.
I know.
And it is to some extent an obligation for me to try to answer questions as best I can. But
Right.
You're asking me to answer questions as a lawyer, and it would be remarkable to put a lawyer up on the stand in the middle of
Well,
the case.
I understand, sir. And so, again, I would like the question answered. Did you see any documents that talked about this interpretation that you're discussing that existed prior to the invocation of the Emergencies Act?
Again, I'm going to rely on solicitor-client privilege there.
And, sir, as the Attorney General of the country, of course, you have ultimate authority both to and to advise on when to waive solicitor-client privilege, do you not?
That's not true. Solicitor-client privilege is not mine to waive. It is up to the Governor and Council to waive.
Right, but you advise on that.
I could advise on that, yes.
Right, okay.
I would remind Council that this is a right that the Supreme Court of Canada has said is a quasi-constitutional right. It is fundamental for good governance, as it is fundamental for any relationship between a solicitor and a client, that the solicitor be able to give full and frank legal advice including all its warts, to a client. In my case, the client is the Government of Canada and my cabinet colleagues, and the Department of Justice needs to be able to tell truth to power. In order to do that, I have a responsibility to rely on solicitor-client privilege, and the Supreme Court has effectively held that this is one of the highest forms.
I'm not going to ask you that question again. But I take it, as an eminent law professor, an academic, with the many publications you have, that between February 13th and 14th, when you were considering this decision, you didn't personally believe that Section 2 of the CSIS Act was any different in the Emergencies Act, did you?
Again, you're asking me to give legal advice.
No, I'm asking
or advice that I might have given to the Governing Council.
No, I understand, but I'm asking you what you personally believe as a member of cabinet.
I am in this case, I can't distinguish that because of the dates and the context that you've given me. You're asking me to apply facts to law, and I can't do that without breaching solicitor-client privilege. I'm not sure you've understood the point.
I understand, but sir, we all know as lawyers that sometimes we give advice and it's not followed. And I'm not asking you to tell me what you advised. I'm asking you as a member of cabinet, was it your personal belief that on February 13th or 14th, did you personally believe that Section 2 of the CSIS Act had a different scope in the Emergencies Act as now being argued? Was that your personal belief?
Mr. Commissioner, the problem here is that asking that personal belief of the Attorney General of Canada inherently gets into matters of solicitor-client privilege. I object to the question.
Sir, I'm asking his personal belief as also a member of cabinet.
I'm not sure. I mean, he's there as Attorney General, as a member of cabinet. That's the problem, I think, that we're running into.
But again, you understand under Section 4 of the Department of Justice Act, it's your duty to see that the administration of public affairs is carried out in accordance with the law.
Absolutely.
And
if you were to ask me the factors that were going on, the events that were going on across Canada that I deemed to be important as a member of that cabinet, I would answer the question. But you're asking me to interpret facts through the law, which is the kind of advice an attorney would give, and I won't do that.
right. And I don't want to know about what you would give as an attorney, but with respect to what you actually gave. But when you're advising on whether to waive solicitor-client privilege, what factors do you consider?
Again, you're asking me a hypothetical question. I would, in probably virtually all cases, advise that it shouldn't be waived, simply because it is such an important fundamental principle.
But you can agree that it's been waived in the past by the government?
I only know of one example.
Okay. Now, just one
You're
last...
going to have to wrap up.
Yeah, I am. And just dealing with Section 39 of the Evidence Act, we just had that, I had mentioned that. You understand that, of course, Section 39 of the Evidence Act applies to cabinet confidences?
Would you read me the provision of the Act or show me the provision of the Act, please?
It's...
I get 38 and 39 mixed up.
Okay. No, it's...
Please show me.
I don't have the ability to show it to you, but Section 39, it speaks to confidences of the Queen's Privy Council. Can we agree about that?
I really would like to see the text.
Okay.
Again, there are a number of numerous texts that I read on a day-to-day basis, and I would like to see the text.
Can you agree with me that it's your understanding that a cabinet confidence is something, or a record that's a cabinet confidence or has a cabinet confidence in it, is something that cabinet would have knowledge of? That someone within cabinet would have knowledge of the contents of the document?
Cabinet confidence is wider than simply what is discussed at cabinet and the recorded version of those. But with that caveat, yes.
Okay. And so with the Section 39 redactions that are in all the correspondence between staffers, everything the staffers say, cabinet would have knowledge of that then?
That's, again, that's a legal opinion you're asking me to give on a controversial point.
Thank you very much, sir. It's been a pleasure.
Thank you.
Next, call on the City of Ottawa, please.
Happy news again, Mr. Commissioner. Alyssa Tompkins for the City of Ottawa. We will not be using our time today. I have ceded it to the Canadian Constitutional Foundation.
Okay. That's good. We have a trading system that has been initiated.
Okay.
So, and it's encouraged.
Okay.
So that those who feel they have a good pitch will have a couple more throws at you.
Right. Okay.
So that's what's happening, just so you know. Next is the Ottawa Coalition.
Good afternoon, Minister Lametti.
Afternoon.
My name is Christine Johnson. I'm counsel for the Ottawa Coalition of Residents and Businesses.
Pleasure.
I only have a few moments with you here today, or a few minutes, I should say, and I'm going to use it to just ask some questions about your own experience of the situation in Ottawa. You've testified today that you were personally impacted by these events, and as a part-time resident of Ottawa, and in fact, you felt forced to leave Ottawa to go spend time in Montreal. That's fair to say?
In addition to changing where I was living in Ottawa as well. I won't say where in either case, but I had to change where I lived too for the time I was up here.
And can you tell us what it was specifically that made you feel like you both needed to change where you were living in Ottawa and then go to spend time in Montreal?
Well, I felt personally threatened when you walked through the convoy and saw some of the banners, saw the Prime Minister hanging off the end of a rope, for example, violent images, and you saw some of the rhetoric that was coming out from the protesters. Sorry, I shouldn't say protesters because it wasn't legitimate protest. The occupiers. And when you saw what the occupiers were doing to my staff and the experiences that they were coming in with, at one point I said, I'm going to Montreal, we're going virtual, because I didn't want to put my staff at risk to have to come into work. All of that made me feel threatened. It only takes one person to recognize me, and I'm often alone, and I would have been vulnerable.
Right. And you mentioned about concerns for your staff, and I think earlier you told us about concerns specifically for female staff, that they were reporting concerns for their safety to you.
Correct.
Mr. Clerk, if we could pull up, please, document SSM.CAN.00007840. And while this is coming up, Minister Lametti, I can tell you that this document is a series of text messages between yourself and Minister Anand, where it looks to be that you're discussing the situation of threats to your staff. Unfortunately, we don't see a date on these texts, but if you take a moment to review it, I'm going to ask you whether you can confirm for me that you are the blue bubbles.
Yes, I am.
And you say had a tough week in Ottawa, team members harassed, back in Montreal, and will do virtual to spare my team. And further down, you tell Minister Anand, even worse, it is the women who feel unsafe. Got my driver to drive them when I could.
That's right.
And just to be clear, you were hearing firsthand stories or concerns reported by your staff?
That's correct.
That's right. And you know, we've heard that you were able to move residences in Ottawa and then go to Montreal, but you would obviously be aware that there were many residents of downtown Ottawa who unfortunately didn't have that luxury or the means to move elsewhere and were stuck in the midst of this convoy.
Yes, that's right. I mean, a number of friends who live in the Ottawa area with whom I am very close.
Right. And is it fair to say then that you didn't need government intelligence to tell you whether the convoy was causing harm to people and businesses in downtown Ottawa, that you saw this in fact for yourself with your own eyes?
Absolutely true. I mean, the Rideau Centre was closed. Again, I'm not going to disclose where I live, but it's something that I see often. I saw other businesses impacted. And I saw and heard from people who were impacted, whose movements changed. And I could see that, as you have said, with my own eyes.
Thank you. Those are my questions. And Commissioner, I think I have 1 minute left and I would cede that to the CCLA. Thank you.
I'm not sure I allow that type of trade, as I've said before. Okay, the OPP, please.
Good morning, Commissioner. Chris Diana for the OPP. I have no questions, sorry, Justice Minister. I will be ceding my time to the CCLA as well. But next time I'm going to drive a harder bargain.
Okay. Next is former Chief Slowly's counsel, please.
Minister Tom Curry for the former chief.
Pleased to meet you.
Towards the end of your evidence to my friend Mr. Cameron's, in response to my friend Mr. Cameron's question, you described the circumstances of cabinet towards the period of time when it was deliberating, I suppose, about the Emergencies Act invocation. I think you said it was a rapidly evolving situation.
That's correct.
You had imperfect information.
That's correct.
You described the circumstances as unprecedented.
Very much so.
And that you were, as a cabinet, I think you said, trying to do your best to get information upon which you could make decisions and take action.
That's correct.
A complex issue.
Very much so.
And do you accept that it was a complicated and complex, unprecedented issue for the Ottawa Police Service?
Absolutely.
And for Chief Slowly, of course.
Yes, indeed.
And that the very same things that you experienced as a cabinet at the in and around the last meetings that you had prior to the invocation were the very same circumstances in which the Ottawa Police Service and Chief Slowly found themselves at the beginning.
In part, yes. I mean, I also witnessed as an Ottawa resident OPS officers standing idly by while people wheeled cans of gasoline down Wellington Street.
Yes. Now, you've not, if I don't know enough about your background to be 100% sure, but I'm pretty confident you've never served in a police service.
I have not.
And in your role as Attorney General and Minister of Justice, you have no interaction with police services.
I do have interaction with police services for reasons of personal security.
Sorry, of course. Apart from your personal security detail, you don't have interactions in your role as a Minister of Justice or Attorney General in with police services, right?
In police operations, no, but I've got friends who are police officers.
Different thing. You've not. You're talking about why a police service member of the Ottawa Police Service stood idly by while a jerry can was by.
All I was trying to do, Counsel, was to say that Chief Slowly's concerns also included a number of other things that weren't on my purview.
Oh, okay. Perhaps I misunderstood. You're not criticizing them for decisions that they may have made about whether to intercept a particular protester, for example, owing to whether they had the resources to do it.
I'm not criticizing Chief Slowly.
Okay. The reason I ask, of course, is because you did in the messages that my friend Mr. Cameron showed you describe him as incompetent.
Yeah. As I said, that was in the heat of the moment. We were all living through a difficult situation, and I'm a human being. I do have personal opinions. I will happily walk that back in the light of hindsight.
Thank you.
But it is the frustration that I felt at the time.
Understood. And I think all of us understand the heat of the moment, the text message and so on. But in this particular case, accepting as you have that it was an expression to a friend, happens to be a cabinet colleague, but this was to a friend.
Correct.
You did not imagine that, and no one should take your words as expressing a view of the Minister of Justice or the Attorney General of Canada.
I think that's absolutely right.
Okay. Because you can understand how when such a thing is made public, that not only Canadians, but the eyes and ears of Canadians through the media take the words to be the weight of your office.
I take that point.
And they oughtn't take those words to be the weight of your office.
That's correct.
Equally, am I right that in the other expressions that you made as a cabinet colleague, the same thing is true, that those words were expressed no doubt as a human experiencing these traumatic events as you've described them, but not expressions of the Attorney General or the Minister of Justice.
To what are you referring?
Well, some of the other, I won't go through them, I don't have the time, but some of the other text messages that expressed what might have been, I think you may have described, or Mr. Cameron described as bad humor, or about Chief Slowly's surname. Slowly in relation to quick, quick, quick. That was an attempt at a humorous remark, not spoken as Attorney General or Minister.
That's correct. And as I said, it was a humorous reference to a movie.
Understood. But as from the chief's perspective, you can appreciate at the time, if your cabinet colleagues formed the view that they should have have less confidence in him, that was neither your intention nor would it be fair. Is that fair?
That's fair.
Okay. And of course, the issue becomes trying to separate a remark from made.
I will say, though, counsel, that it was very frustrating that we were promised plans, or plans were forthcoming, or plans were in the offing, and they didn't seem to materialize.
Yes, although, of course, you're not entitled to review an operational plan as a Minister of Justice or the Attorney General.
Just wanted to know the existence of them.
Yes, and as to that, just in the time I have remaining, I take it that you didn't know no one was providing you with information about what the OPS had as a plan or didn't have as a plan at the cabinet table, correct?
Not the details, but
Right.
but we were getting reports from the commissioner of the RCMP
Right.
about the OPS and its development of a plan.
And do you now appreciate that some of the information that you received from the commissioner, up through the commissioner of the RCMP, was not accurate?
I can't speak to that. I'm not in a
Okay.
position to say.
Suffice it to say that you were relying on what was told to you about what resources were available and whether there were plans at certain dates, but you can't vouch for any of that.
Absolutely right.
Okay. Last thing, please, if I may, just as to resources. You sent a note to the Attorney General, your opposite number now, Attorney General Downey in Ontario, to urge him to speak to the Solicitor General about priorities, Windsor and Ottawa.
Well, it was more that the priority, the reason why I reached out was there was a perception that Ontario was not dealing with federal counterparts.
Yes.
And that the Solicitor General should be at the table with others. That was it. It wasn't in any way meant to direct them, but we could identify priorities across Ontario, and there were many.
I share for what it's worth, I share your view that is the role of government, to set priorities and for police to make decisions afterwards. But just as to that, did you have an appreciation in cabinet that there was a kind of unfortunate after you, Alphonse, moment between the federal government and the Ontario government as to which government was the first port of call for the Ottawa Police Service to receive resources?
My understanding is that as a matter of jurisdiction, Wellington Street was a provincial jurisdiction.
Right. Did you appreciate that Ontario took the opposite view?
I can't speak for Ontario on that.
Okay. I'm out of time. Thank you, Minister.
Thank you. The Union of British Columbia Indian Chiefs, please.
Good afternoon, Minister Lametti. My name is Cheyenne Arnold Cunningham, and I'm counsel for the Union of BC Indian Chiefs.
Good afternoon.
This inquiry is, among other things, considering the extent to which state emergency powers or exceptional policing powers should be used when there's a public order event. For Indigenous peoples, it's often been the case that they must assemble and organize into a social movement to seek attention to the denial of their rights or even advance the recognition of their rights. Sometimes the response of police and the Government of Canada has been to target or punish Indigenous peoples for organizing, for speaking up for their rights, for upholding their traditional laws, and treating these events as emergency events. Should the approach to public order events, specifically when it's Indigenous peoples involved in defending their rights, take into account their distinct and unique contexts as Indigenous peoples, including the long history of government denial of their rights and, as you mentioned earlier in your testimony today, the reality of racism and anti-Indigenous discrimination in policing and our justice system?
Thank you, Council. Thank you for that question. It is a long question and a complicated one. So I guess the easiest way is to say yes from the outset, that I do think we need to move towards, and we need to move quickly, towards a series of practices, procedures, and principles that make consultation with, cooperation with, even co-policing with Indigenous peoples part and parcel of what we do in every situation, including emergencies. The Emergencies Act itself didn't have a consultation requirement with Indigenous peoples. That's just a result of the years in which it was drafted, I think, and the different sensibilities at the time. That's something I would commit to change if, as we move forward, we'll get the report from Commissioner Rouleau, and we will see what recommendations are in there. But I do think that we need to have a more formally incorporated consultation requirement in the Emergencies Act with respect to Indigenous peoples. We did that informally. The Minister of Crown Indigenous Relations did reach out in this case to the heads of the 3 national Indigenous organizations, but it could be better done down the road, and it needs to be more sensitively tailored to different nations, regions, and Indigenous organizations as we move forward.
Okay, thank you. As Minister of Justice, you brought forward Bill C-15 to implement the United Nations Declaration of the Rights of Indigenous Peoples, also known as UNDRIP, and this was a major shift in affirming the recognition of Indigenous rights, and now there's a process to prepare a federal action plan. Under this legislation at Section 5, the Government of Canada is mandated to take all measures necessary to align the laws of Canada with the requirements and minimum standards embedded in UNDRIP. Can you describe how Justice Canada is meeting this obligation? And considering we only have a little bit of time, if you could keep it specific to policing and public order events, that would be helpful.
Okay, we are developing the action plan as we speak, and we're working hard with the variety of forms of Indigenous leadership across Canada to decide together how we move forward. So which laws to change according to Article 5 of UNDRIP. I suspect the Emergencies Act will be one of them. But I can also tell you that my colleague, Minister Mendicino, as the Minister of Public Safety, is working very hard with questions of reforming Indigenous policing or peacekeeping, or the better policing of Indigenous nations and peoples by police officers, whether Indigenous or not Indigenous, and that will wrap into how we move forward.
Okay, thank you very much for your time today. Those are all of our questions.
Thank you.
Okay, thank you. Next, call on the Canadian Constitution Foundation, please.
Yes, good afternoon, sir. Can you hear me okay?
I can indeed.
All right, so my name is Janani Shanmuganathan, and I am counsel for the Canadian Constitution Foundation. And the issue I would like to talk to you about today is the definition of threats to the security of Canada in the Emergencies Act, okay? So we know that Section 16 of the Emergencies Act refers to the definition in the CSIS Act and says, threats to the security of Canada has the meaning assigned by Section 2 of the Canadian Security Intelligence Service Act. Now, we heard from Mr. Vigneault earlier this week, and he's the director of CSIS, and he told us that CSIS has a very clear understanding of what threats to security of Canada means in the CSIS Act based on legal interpretation, jurisprudence, and federal court rulings. And we also heard from him that as far as CSIS was concerned, in terms of what was going on during the convoy, the definition of threats to the security of Canada in the CSIS Act had not been met. Now, are you aware of his evidence on this point?
I am, but then the CSIS director did go on to say that he supported the invocation of the Emergencies Act in this context.
So you'll agree that as far as CSIS was concerned, the definition under the CSIS Act had not been met.
I disagree with that. I have already, with counsel in a descriptive way. Again, I should start with the initial caveat that I'm not going to. I'm going to be careful with respect to solicitor-client privilege. I'm not going to link facts to arguments in a way that can impute the kind of legal advice I may or may not have given or may not have been given to me in this process. And I have to maintain that privileged argument. But I think you have heard from a series of witnesses this week, including Mr. Viano, including the exchange I had earlier with counsel, that the incorporation by reference of Section 2 of the CSIS Act into Section 16, given the different purposes of the CSIS Act, given the different goals that CSIS has with respect to why it is using a Section 2 definition for one of its investigations in order to get to further inquiries, is different from the context in which it has been incorporated into the Emergencies Act, and the decision-making body is different. It is not CSIS. It is the Governor and Council. So there is a wider, as you've heard from a number of different witnesses this week, there is a wider set of inputs that are more than just CSIS inputs. You've also heard from CSIS about the specific rules of thumb that they use in order to interpret Section 2, which aren't necessarily imported into Section 16 because it's a different decision maker.
And all I want to confirm, sir, is that as far as CSIS was concerned, using their interpretation of threats to the security of Canada, that definition was not met under the CSIS Act.
And for the purposes of CSIS in the CSIS Act, yes, I'll agree with that.
All right. And now, we've also heard that Mr. Vigneault was provided a legal opinion that explained the separate interpretation of this definition under the Emergencies Act. And I take it if I asked you anything about the substance of that opinion, you'd say it's covered by solicitor-client privilege?
Indeed, I would.
All right. And now I just want to understand, who is the client in this solicitor-client privilege? And the reason why I ask is, who is the person that we need to approach to waive this privilege so that Canadians can understand how the government arrived at this different interpretation of threats to the security of Canada? Who is this client?
Well, the client is the government of Canada. I don't think I'm telling tales out of school when I say that in closing argument, I believe these kinds of questions will be addressed by counsel.
All right. And so I want to now shift and take you back in time to look at what Minister Beattie, the Minister of National Defense, who is the sponsor of Bill C-77, the Emergencies Act, said about the definition in the Emergencies Act when the legislation was introduced. So if I can ask to bring up POE.CCF 603. And just for context, this is a speech that Minister Beattie gave to the House of Commons debates during when Bill C-77 was debated. And specifically, I'd like to go to page 5, please. Is that page 5? Perfect. So I just want to take you to the highlighted portion. Perhaps if we can make it bigger so that Minister Lametti can see it.
I prefer it smaller so that I can see the context, please.
So
This
just want to
is
take you to
fine the way it is.
So the highlighted portion where it says likewise, what Minister Beattie says is likewise, it has been said that probably the most contentious clause in this bill is the one that deals with public order emergencies. This is the type of situation which gave rise to the use of the War Measures Act in 1970. This clause takes its definition of threat from the Canadian Security and Intelligence Services Act. This fact alone should make us very cautious because of the difficulties already encountered with CSIS in determining what is subversion and what is legitimate dissent. That was one view of the legislation. He goes on to say, I would remind members of this House that the definition of threats to the security of Canada received exhaustive scrutiny by Parliament in 1983 during deliberations on the CSIS Act. The language in this definition has therefore already received Parliament's blessing. So I pause here to note that what Minister Beattie is saying is, we are specifically incorporating the definition that's found in the CSIS Act because this is a definition that Parliament has already blessed. Is that fair?
Commissioner, again, going to Hansard's is something that is frequently done in the course of legal argument to interpret a statute. It's my submission this is not a matter of fact evidence. This is a matter of argument which will be done at the end of the case, and it's not a proper line of questioning for this witness.
So I would say in response that, this is something that I'm asking Minister Lametti to explain about how, he's offered an explanation for why there's a different interpretation under the Emergencies Act because the purpose for that definition is different, or determining the purpose is different. And what I say is, well, I'd like to look to see what was described as the purpose under the Emergencies Act and why they use that particular definition. So I would say that it is an appropriate line of questioning.
I think it's appropriate to ask him what the purpose of the CSIS Act is, if that's what you're doing, as I understand it. And I'm not sure that requires anything beyond his understanding. I mean, if it's a legal interpretation of what the CSIS Act means, that's different. So what is it you're trying to get at from him?
So what I'd like to do is I would like to go through Hansard and have him confirm what the understanding was in terms of what Hansard said about why they used the CSIS Act definition and incorporated it into the Emergencies Act.
Yeah, I'm not sure he can interpret any more than read the words, but I think that's the best you can get from him.
Well, the point that I was going to make, Commissioner Rouleau, was in the very next paragraph, which was the CSIS definition is embedded in the Emergencies Act and it must be read in conjunction. And that changes the scope, and the decision maker has changed, and that's all really I'm comfortable saying.
And sorry, Justice Rouleau or Commissioner Rouleau, Minister Lametti has referred to a following passage in the highlighted portion. And if I could, I just want to go to the next passage so I can ask him a couple of questions about it, because he's now commented on that.
Sure, go ahead. Let's
All
see
right,
where
so
it goes.
Thank you. So Minister Lametti, you referred to the fact that must be read in conjunction with the definition of national emergency. So when you move to the next page, to page 6, what the entire paragraph says is, I would also remind the House that the definition at the head of each of the 4 major parts of this bill, including the definition of threats to the security of Canada, do not stand alone. They must be read in conjunction with the definition of a national emergency in the preamble of the bill and in conjunction with other restricting provisions. In other words, before the government can declare a public order emergency under Part 2, the emergency situation must correspond to the definition of a national emergency as stated in the preamble. They go on to say, I am told that this double test, as it is called, will be used by the courts to assess the government's compliance with the deliberate constraints and safeguards that have been built into the definitions of this bill. So what I'm saying, Minister Beattie is saying here, is that you have to, 1, meet the threats to the security of Canada, that's the first part, but also meet the definition of a national emergency under the preamble. That's what he's referring to as this double test.
That's certainly your point of view.
All right. And is it fair to say that they're not saying here that the interpretation of threats to the security of Canada changes because you're looking at it through the lens of a national emergency? They're talking about this two-part test, a double test.
Again, Mr. Commissioner, my friend's question is calling upon the witness to interpret what we see in the Hansard. The Hansard is what it is, and beyond that, we're getting into legal argument on the interpretation of the legislation.
So I'm afraid you're also out of time, so you're going to have to wrap up, and I think you've probably gone about as far as you can with interpreting Hansard.
Okay. Those are all my questions on that. Thank you very much.
Okay, thank you. Unfortunately, you're going to have to come back after lunch if that's not a problem, because I think we have over a half hour of material left.
That's fine. Thank you.
Okay, so we'll adjourn and take the lunch break for 1 hour. Come back at 2 o'clock.
The commission is in recess until 2 o'clock. La commission levée jusqu'à 14 heures. The commission is reconvened. La commission reprend.
Okay, je m'excuse pour le retard. I apologize for the slight delay. I'm sure anticipation for a continued exciting examination. So the next, I believe, is the JCCF, Democracy Fund.
Good afternoon, Minister. My name is Alan Honor. I'm a lawyer at the Democracy Fund. We share status with the JCCF and Citizens for Freedom. Can we please pull up ssm.can402665? Minister, while we're waiting for that, you will recall that on February the 14th at around 4:30 p.m., you held a press conference with the Prime Minister as well as other ministers. And at that press conference, Prime Minister announced the invocation of the Emergencies Act. If we could scroll down to the bottom of this document, about halfway down the fourth page. No, I think we have the wrong document, 2665. That's it. If we can scroll down to the bottom of the document.
Can I see the top of the document, please, first? Okay.
Okay, at the bottom of the document, we see that this is an email from Emily Cantor of the PMO's office, and it's dated February the 13th, 2022. And it is sent to David Taylor, among others. Can you confirm for me that David Taylor was your Director of Communications?
I can confirm to you that he still is my Director of Communications.
Okay, thank you. And this email is referring to a noon press conference happening on the 14th with the Prime Minister and a number of ministers. And it says...
I'm not a party to the email, so I'll take your word for it.
That's right, but you can see it in front of you, right? And it says at the press conference is to provide an update on the federal government response to the blockade as well as the Ukraine.
That is correct. That's what it says.
And that ended up being the press conference at which you and the Prime Minister announced that the Emergencies Act was being invoked.
That would be the timing of it.
Okay, so let's just scroll up to the the bottom of the second page. That's great. And if we can just scroll down a little bit so we can see this entire email. That's good, thank you. Here we have an email from Vanessa Haig Musa at the PMO's office saying, presser tracking for 4 p.m. This is not to be shared publicly until First Minister's meeting over and PM updated itinerary is out. Do you see that?
I do.
And Minister, I put it to you that the reason this press conference was not to be shared publicly until after the First Minister's meeting is because the Prime Minister and Cabinet had already decided to invoke the Emergencies Act before the First Minister's meeting took place, and it would not look right if the press conference, which would ultimately announce the Emergencies Act, was scheduled before the end of that First Minister's meeting.
You're completely off base.
Okay, well,
the communications teams, I mean, first of all, I'm not party to the email, but the decision-making process was tracking. The final decision was not made until the Prime Minister did, but communications teams will prepare for the eventuality that this might happen. I have seen in my political career in the past 7 years, you asked me the question, sir.
But sir, I just want you to agree
I
or
have
disagree.
seen in my political career tracking announcements, you see the word tracking?
Yes.
Tracking announcements get completely pulled at various stages, including the last minute.
Thank you,
So
sir. I only have 5 minutes. If I could just continue with this email.
But you want the context of this email.
No, I
because
don't want the
well,
context.
I would like to
I just
give you
want
the
to put it
context
to you
of
to
it.
see if you agree with it or not, and you disagreed.
I disagree strongly that this means absolutely nothing.
Thank you, sir. Then if you disagree, I would like to take you to another part of this email. You'll see that this email that we're looking at right now is at 11:05. And obviously from the context here, the First Minister's meeting has not yet finished. You can agree with that, yes?
Is 11:05 the time? Because there have been some emails that
Well,
have
but from the
been on
context,
GMT.
it says this is not to be shared publicly until the First Minister's meeting is over. So from the context, the First Minister's meeting is not over at the time this email is written, correct?
As I had said, the communications teams will be preparing for the possibility that there will be an announcement. They do not go with it unless it happens.
Sir,
but
you
they
can
do
agree
have to prepare. They do have to prepare. They're doing their jobs. They do have to prepare. I'm sorry that you don't
Sir,
like that
only have
answer, but
5
it is the
minutes.
truth.
I just want to know if you agree with me that the First Minister's meeting had not taken place yet.
I'm not a party to the email, so
Okay.
I'll take it in terms of what it says, but they're just planning for
Okay,
their
so,
job,
sir,
quite frankly.
If we can continue here. This email says, as discussed with you, Minister Lametti will also have brief remarks. And if we look up the page, there's a response to this email from David Taylor, your communications director, saying that he is drafting your remarks. Do you see that?
Yes, I do.
And the timing of that email is 11:06. That's exactly 1 minute after the email we just read.
That's correct.
And so, sir, what we see here is that David Taylor is drafting remarks, your remarks for the 4:30 meeting at which the invocation of the Emergencies Act was announced. And he's drafting those remarks before the end of the First Minister's meeting.
Yes, but it's all hypothetical because
Well, I put it to you,
I
sir.
have seen it. You can put it to me and I'll give you the answer, which
Sure,
is
then I put it to
it
you,
is
sir, that
not
the-
final until it's final. I have seen these announcements pulled 5 seconds before it's supposed to happen. They are preparing in order that it might happen. That is their job. That's why I pay David Taylor. And the same is true for PMO Communications and everyone else. That's
sir, I put it
good
to
governance.
you-
We're preparing for the eventuality that it will happen, but it does not happen until the final decision is made.
Commissioner, may I have 2 more minutes?
Sure.
Sir, I put it to you, you'll agree with me that the remarks you did make at 4:30 were in fact about invoking the Emergencies Act. And I will not put it, I will not call it up, but it's in the record, it's OTT 407224-0001. That is what happened at 4:30 that day on the 14th.
I made remarks only after the final decision was made.
Okay, can we please pull up ssm.can 408737? So this is a text message exchange between you and Greg Fergus. And if we can just stop for a moment, he says, Marco is talking at the meeting with, and we can't see it because it's covered up by the date, which is February 13th. It says caucus. And if we just go down a little bit, you talk a little bit about it's you in the purple. Our only other legal option is the Emergencies Act. Mr. Fergus says, that's exactly where people are at. It is where I am at. You respond, and me, and Marco, but he's being a good soldier. If we can scroll down, now we have Mr. Fergus say at 1:28 p.m. on the 13th, consensus from our call, 1, use the Emergencies Act. he goes through a couple of other criteria, but let's just scroll down a little bit. And you don't contradict him, do you? You don't contradict him at any point that that was the consensus coming out of your call on the 13th.
He's not a member of cabinet, so I'm not going to confirm or deny that. He's a colleague. He's a caucus colleague. This was, if you scroll up, please. This is after a caucus call. So those are his reflections after a caucus call. They are, I think, a good reflection in Mr. Fergus's view of what this was. And I think this confirms, quite frankly, that a final decision had not been taken.
Well, let's go through the text message.
Even though I must admit that I was now at the point by February 13th where I thought the Emergencies Act should be invoked. It is, I prepared my colleagues from the beginning for the possibility that this would happen, as a good Attorney General would do, as a good Minister of Justice would do, from my experience from the pandemic, where I also prepared my colleagues and we didn't use it. By the time we got to this third weekend, I had come to that conclusion. That's evident here. But as you can see, no decision had been taken.
So the text message is in evidence. We'll leave it for submissions. If I can just put one more document to you, and this is ssm.can408754. So I started off this examination by talking to you about the invocation of the Emergencies Act. Now I just want to talk to you very briefly for about 30 seconds about its revocation.
Sure.
This is another email exchange between you and Greg Fergus, and he says on February 23rd, I am glad we ended the EA, but it would have been more appropriate if we waited until Friday, 44 hours after the vote seems unseemly. And your response is, no, we needed to stay ahead of the NDP, and the senators were saying that they would vote against based on their view that there was no longer an emergency. That is your text message with Mr. Fergus?
It is indeed. And although we did have the votes, and although the vast majority of senators understood that they were being asked to vote on the Emergencies Act at the time at which it was invoked, there were a number that didn't understand that. We had said from the beginning, sir, that we would not keep the act a minute longer than we needed to. It's something we said to the NDP, and it's something that we said to senators. And I'm being completely consistent here to say that we needed to be ahead of that in terms of keeping our promise in order to not keep the act in place a minute longer than necessary, and that's precisely what we did.
And this is my last question. I put it to you that this text message shows that, in fact, you would have kept the Emergencies Act in place for longer had it not been for the fact that you were concerned that the NDP would withdraw their support and that the senators would vote against.
I reject that premise. There are other text messages that you will see where we have predicted that we had sufficient votes.
We'll leave that to submissions. Thank you very much, Minister.
Thank you.
Okay, next is the CCLA, please.
Good afternoon, Minister Lametti. My name is Kara Zwiebel. I'm counsel for the Canadian Civil Liberties Association.
Pleased to meet you.
I'm no Alan Borovoy, but am a big fan. So,
as am I.
I'm going to, I do have some time. I want to thank my friends from the OPP and the Ottawa Coalition for giving me some of their time. Mr. Cameron took you to the McClellan report, and there was some discussion about your roles. Would you agree with me that you are not only the chief advisor, legal advisor to the government, you are also considered as Attorney General the guardian of the rule of law and of the Constitution?
Very much so, yes.
Okay. And in your witness statement, and we can pull it up if we need to, but I don't think I'm misstating it here. You noted that the decision as to whether there was a national emergency was a political one. Do you agree with that?
Well, it was a political application of the various textual rules based on facts that we had.
Okay.
So it's made by, what I mean there is it's made by political actors. It's made by the governor and council.
Okay, and do you agree, though, that though it's a political decision, your role, one of your roles, was to assess the legality or the constitutionality of both the decision to invoke and the orders that
Could I see that text, please? Because I think you're reading something in that,
Sure.
that doesn't
Yeah, witness
represent what
summary
I
is
thought.
WTS 6077, and it's on page 4, the bottom of page 4. It's under the heading Existence of a National Emergency. And if you scroll down to the last paragraph, it says Minister Lametti further explained that the determination as to the existence of a national emergency was a political one. It was formed on the basis of factual inputs from implicated government departments, including PCO, and legal opinions provided by the DOJ.
Yeah, I mean there, and the context now makes it clear that it's made by political actors, so the governor and council. It's not made, for example, by CSIS.
Understood.
And I've clearly stated in that what the inputs were, and I think it makes it clear. So when I say a political one, I mean it's a decision made by political actors, but it's not a political decision in the sense that I think you were understanding it.
Okay. You talked with some of my friends about the different possible, I guess, interpretations of threats to the security of Canada as set out in the CSIS Act versus the Emergencies Act. And I don't want to get into, and I'm not asking about your legal advice here. Would you agree with me that in the CSIS Act, what we're talking about is whether, for example, CSIS can wiretap an individual?
Amongst other things, yes.
Okay. And with the Emergencies Act, what we're talking about is whether the government can put in place orders that have the potential to restrict the rights of every person across the country.
Have the potential, yes, but of course the Emergencies Act is subject to the Charter. And as you have quite rightly mentioned, part of my role is to make sure that whatever we do is Charter compliant.
Okay. We're going to get to the Charter. I want to talk a bit about the communication around the invocation of the Act. We can pull it up if we need to, actually. It's SSM CAN 404415. These are technical briefing notes, I think, that would have been prepared for you by someone in your office around potential questions that you might get about the Emergencies Act. And if we can go to page 3, sorry, you can see the beginning of the document there.
Yeah.
Page 3, the CSIS threat definition is discussed here. And the second question is, on what basis does the governor and council determine that the ongoing protest situation reaches the level of threats to the security of Canada? And it says, as defined in Section 16 of the Emergencies Act, given the meaning assigned in Section 2 of the CSIS Act, threats to the security of Canada includes, and it lists those 4 things. Do you see that?
I do.
Okay. I can take you to it if you want, but are you aware that in the CSIS Act, threats to the security of Canada means those 4 things? It doesn't include them, it means them. And I'm sure as a law professor, you know the statutory interpretation difference between those 2 things.
I do.
Okay. So would you, do you need me to take you to the CSIS Act?
Oh, no, it's fine. I believe I have answered to the point that I can answer with previous counsel. So
Okay.
I'm not sure I can add anything else. If you want me to repeat myself, I
Nope.
will, but it's your time.
No, thank you. And I know now we've heard over the course of the commission's time that in terms of the CSIS Act, it's Section C that the government was relying on here.
That's correct.
Okay, but here we have all 4 potentially laid out. There's also a news release that was put out when the Act was invoked, and that's COM 50657. And you know what, I'm not sure I have a page number written down here. public. If we can scroll down further, keep going. So it lists the measures that will be put in place. And here it's describing what has to happen in order to declare a public order emergency. And sorry, stop right there. Thank you, Mr. Clark. It says threats to the security of Canada may include the threat or use of acts of serious violence against persons or property. So again, there we're using discretionary language instead of the sort of the mandatory language that's in the Act. Do you agree?
This is a news release.
Understood.
It isn't meant to be comprehensive.
Understood. This is what's communicating to the public about why the government is doing what it's doing.
Right. I would put to you that it's not misleading, although although you may have wished to have more technical detail as a lawyer, but it is not misleading in terms of its general direction.
Okay. Let's talk about the charter. I know that when the Emergencies Act was invoked, and I think we've seen some documents, there's concern that some people think that the Emergencies Act suspends the operation of the charter. And I take it that that is something that you are concerned about and that you want to provide people assurances that that's not, in fact, what the Emergencies Act does.
That's true.
Okay. And you said, I think, in a couple of your statements publicly when the Act was invoked that lawful protest was permitted.
Correct.
Now, were you getting a sense by this point that maybe people that were participating in these protests did not have a clear understanding of what a lawful protest was?
I think that may be true for some, but they were participating in an unlawful protest. They were participating in a protest that was trampling on the rights of other Canadians, the Section 7 rights to security. They were having a negative impact on mental health. They were having a negative impact on people's mobility, both in urban areas like Ottawa, but also at border crossings. As a group, they were harassing Canadians, and there were threats of violence. We saw a plot uncovered in Coutts, Alberta. There were reports of violence, reports of guns possibly present in Ottawa, and there was the tracking of potential IMVE throughout this. So they were participating in that. And despite messaging to try to say, go home, people weren't listening.
Okay.
So this was not a legal protest by any stretch of the imagination. It was quite illegal, and the Emergencies Act dealt with it.
When Minister Mendicino was here yesterday, he said that he believed that although he would characterize, I think, it the same way, that the protest was illegal, that there were thousands of people who were aiming to protest lawfully, and thousands of people who were. So not people who were blocking trucks, people who were simply on the streets, on their feet, protesting peacefully.
Yep, I grant you that possibility.
Okay. And the orders that were put in place under the Emergencies Act required those people to leave the area.
That's correct.
Well. Thank you.
They always had the option to go somewhere else to protest legally. When the blockade was cleared, people moved down the street, Wellington Street in Ottawa, towards Booth, and they protested on the side of the road, not impeding traffic, not impeding pedestrians, manifesting their political beliefs, waving signs. That was completely legal. Throughout all of this, those people had an option to move to protest legally, and they didn't.
Okay, I want to talk about the financial measures that were put in place, and if we can go to SSM CAN 404423. Would you agree that the financial measures gave both police and financial institutions discretion to freeze assets of individuals who were engaged in unlawful activity as it was defined under the emergency orders?
Yeah, I think that's right. The language used, to my recollection, was generally mandatory, but nobody would have quibbled with discretion had it been applied. Again, this is a hypothetical situation. I don't know any cases where this actually happened.
You don't know any cases where people's assets were frozen?
No, where discretion may have been applied.
Okay. Well, we did hear from police, for example, that even though the orders captured insurance companies, for example, they didn't provide any information to insurance companies. It sounds like they partly didn't have time to get to that, but also they were concerned that if insurance policies were suspended, trucks would not be able to leave the area. So that's one example of where some discretion appears to.
That may be true. There was anecdotal evidence, though, that the measures put into place had the impact of inciting people to go home and to take their trucks home.
Okay, this is an email from you to some of your staff, and it's actually further down that we're interested in, if we can just scroll a bit. So this is one of your staffers is telling you that there's a part of your interview, I think this is with Evan Solomon, that's circulating on Twitter with clickbait-style captions saying that people who've donated to a pro-Trump cause, any pro-Trump cause, could face legal, financial consequences. Matt Gurney has seen this being circulated, has asked for clarification, and they've got a little statement that they are asking you to approve.
That's right.
And it says, we always ask our police forces as well as our prosecutors to act reasonably, where they're going to work with the banks to ensure that they act reasonably. Obviously, there are going to be judgment calls that will be made, and serious contributors will be treated more seriously. But as always, we're going to leave it to law enforcement to work with the banks, as they already do in other areas that already exist, such as in anti-terrorism financing and in other areas through FinTrack. And further down in this email is the transcript from your interview with Evan Solomon. And he's asking you about the possibility of donors being targeted by these measures. And if you can scroll down to the third page, the bit that's highlighted, this is the bit that sort of led to the confusion. But would you agree with me that here you're not saying that someone who's donated couldn't have their assets frozen? That is contemplated by the orders.
That's right. I chose language that I probably shouldn't have used in the framing of this. What I meant to say is that if you happen to live in the United States and you're supporting what's going on in Canada, then you ought to be worried that these financial measures could kick in.
Okay.
The other clarification I would also stand by with respect to the discretion, and I think that was a legitimate follow-up question to which we gave a legitimate clarification.
And then this will be my final my final bit. This is, I guess, we've heard about CSIS 101. I want to talk about OAKS 101. Talked about the proportionality, the need for all of the measures under the Act to be proportional. And would you agree with me that proportionality is assessed in context? So when a court is looking at whether government action or measure is proportional, it assesses it against the objective that the government is trying to achieve.
Absolutely right. And I'm glad you asked that, because it allows me to say that we took targeted, time-limited, temporary measures that focused on specific areas of the occupation that we needed to get at. The financing, as well as the geographical definitions and a few other things. The measures we took were specific to the blockades. They were time limited. I believe they passed charter muster, and they were quite proportional to the task at hand. And I think in this is the one time I will go to hindsight, they worked quite well and quite efficiently.
Okay, and by invoking the Emergencies Act, the objective is to address a national emergency, a threat to the security of Canada under the Emergencies Act.
That's correct.
Would you agree that but for the invocation of the Act, the orders that were in place would be unlikely to withstand constitutional scrutiny?
Mr. Commissioner, I don't think that that's a fair question. It's a hypothetical, and it's seeking a legal opinion.
I think the minister's indicated by his nod that he might agree with me, but I'll leave it there. Thank you, Minister.
Oh, I was actually just thinking.
Thank you, Commissioner.
Okay, thank you. Next, all on the City of Windsor.
Good afternoon.
Good afternoon.
Minister Lametti. My name is Jennifer King. I'm legal counsel to the City of Windsor.
Pleased to meet you.
Mr. Clerk, I would like to show Minister Lametti Win 932. And if you could go to page 8, I'll explain to the minister what this is. Mr. Lametti, you are aware that the Automotive Parts Manufacturers Association, supported by Windsor and Ontario, successfully sought an injunction to end the blockade of the Windsor Bridge, or the Ambassador Bridge. Were you aware of that?
Yes, I was.
So the first injunction was effective Friday, February the 11th. Windsor Police and the OPP, together with their policing partners, safely cleared the bridge over that weekend. And then, although the bridge was reopened to traffic just after midnight, the morning of February the 14th, the City of Windsor sought to continue the injunction. You're aware of this?
I am indeed.
Okay. So the Chief Justice granted this extension on February the 18th. This is the Chief Justice of Ontario's decision regarding the extension. Have you seen it?
I have seen parts of it, and I now have it in front of me.
Great. So I'm just going to ask you some questions about the findings that the Chief Justice made on the evidence that was before him on February the 18th. The Chief Justice found that the city had established a prima facie case that the protesters had breached multiple bylaws and continued to do so after the order came into effect. You're aware of this?
I am.
Okay. The court also found that protesters breached the February the 11th order as evidenced by multiple arrests under the criminal code for breach of an order.
I'm aware of that as well.
Did you share the Chief Justice's concern that protesters would continue to breach the law?
Yes, and it's certainly consistent with the information that we were getting, both from Windsor and other places.
Right. So the Chief Justice also found in this paragraph 47 of the decision, which is before you, shows that the Chief Justice also found, based on the evidence that was presented to him on that day, that there was a risk that protesters would reassert presence on the roadways to block access to the bridge. Minister Lametti, were you also concerned at that time that, about the risk that protesters would return and block the bridge again?
Very much so, including even after the bridge was cleared later that day and the next day. We were monitoring very closely what police reports were saying. There were reports that people were coming back, or in fact, when the blockades began to be cleared in Ottawa, that trucks would leave Ottawa and go to Windsor to the Ambassador Bridge. So we were monitoring all of that, but it was very much alive in our concerns.
Right, and that was all before the Chief Justice on February 18th when he heard the continuation of the injunction.
That's correct.
Mr. Clerk, if you could please go to page 10, paragraph 59. In considering whether a permanent injunction was appropriate to enforce municipal bylaws, the Chief Justice used strong words about the importance of the rule of law. And he says in paragraph 59, the rule of law requires that everyone obey the law. Significant, organized, deliberate, and persistent defiance of the law and court orders is a serious threat to the rule of law, which is one of the foundations of a functioning democracy. Minister, in your view, did the protests and border blockades in particular threaten the rule of law?
Absolutely. Absolutely. And I would add, as I stated with the previous council, that there was always the opportunity to conduct legal protests, but the method chosen had a deleterious effect on many other people.
And can you tell the Commission, in your view, what are the consequences of these threats you saw to the rule of law?
Well, it undermines the ability of people to live, to work, to function. It undermines their mental health. It undermines their sense of security. And that undermines our functioning democracy. It undermines the ability of decision makers to make decisions, democratically elected decision makers to make decisions. And you can agree or disagree, but there's a process for disagreement. And that process has served our country well since its inception. This completely undermines that. It's the rule of the mob as opposed to the rule of law.
Minister Lametti, the next paragraph, we see that the Democracy Fund, which is a party here before this commission, attended at that hearing as an intervener friend of the court and argued that an injunction was not warranted as there were other enforcement remedies to address the unlawful conduct, including the Emergencies Act. Because as we know, the Emergencies Act was already invoked at that time. And I just wanted to point out for you, I'm not sure if you knew the decision in detail, but that argument was rejected on the basis that the test for a statutory injunction under the Municipal Act does not require consideration of the availability of other enforcement remedies.
Right, I knew that. I would add that nobody has a monopoly on irony.
Great. So in paragraph 68, I have one more question, Minister Lametti, although perhaps your answer may take more time than I have. At paragraph 68, the Chief Justice concluded by repeating a statement from his reasons on the initial injunction. And he says, simply put, freedom of expression does not extend to the point that the protesters' activities can result in the denial of fundamental rights and freedoms to all those detrimentally affected by the blockade. Could you just, I know we don't have much time, but can you unpack this balancing of rights for us just briefly? Does the extent of an individual right or freedom under the Charter have to be measured against its effect on other members of the community and their rights and freedoms?
Thank you. I agree with every word that Chief Justice Morowitz has written here. Rights are not absolute, and one's own individual rights go as far as they do not detrimentally affect the rights of others. It's always a balance. With respect to peaceful protests, there's always going to be a bit of inconvenience for a short period of time. But when you lock in and you block people from living and working and sleeping at night because you're honking your horns or can't get your children to school or to the hospital because you've impeded traffic, or you've blocked a bridge in Windsor that is vital for the economy of not just southwestern Ontario, but the whole country, and the impact that that has on families and on mental health and the stress that it puts on people, all of that is so far beyond the legitimate exercise of free speech, freedom of expression, particularly when there's always an option to do it legally in a time and place and space that doesn't have that deleterious impact on other people.
Thank you. Those are my questions.
Thank you.
Okay, next, the Windsor Police Service, please.
Good afternoon, Minister Lametti. Can you hear me okay?
I can indeed. Good afternoon.
Okay, wonderful. My name is Heather Patterson. I'm the lawyer for the Windsor Police Service. I just have a couple questions for you today. You said several times this morning that government cannot direct operational decisions of police, correct?
That's correct.
And that extends to the police decision of how to allocate and use resources, correct?
Yes, in terms of operations, but there are larger decisions where, at the very least, according to what was written in the Ipperwash report, governments can make their priorities known in certain contexts, particularly these kinds of emergency contexts.
Right, and you said that. You referenced the Ipperwash a couple times this morning.
That's correct.
And that sort of non-directional would also apply to the police operational decision on the timing of actioning their plans. Correct?
Yes, indeed. Although, as I've pointed out, it is legitimate for government to ask that there be a plan in existence.
Right. And you agree that any enforcement operation by police needs to be planned and methodical and properly resourced?
Absolutely.
And that it should be peaceful as possible and in line with protecting protester rights and charter rights?
That's true.
Okay, and are you, my friend just took you to it, but I just want to confirm you were aware that enforcement actions were underway in Windsor on February 12th and the 13th, and that the bridge was reopened just after midnight on the 13th, or morning of the 14th, correct?
That's right. And as I had said, even conversations later on the 14th indicated that we were still worried that continued occupations might be reasserted of the Ambassador Bridge.
Okay. And prior to those enforcement actions on the 12th and 13th, you weren't provided with a copy of the operational plan, correct?
That's correct.
And you were not receiving regular briefings by Windsor Police Service on the operations, correct?
That's correct as well. I was receiving indirectly the news that an operation would happen, but no detail provided to me directly.
Okay, and you also were not receiving regular briefings from the OPP as the enforcement action took place in Windsor, correct?
That's correct.
So was the source of the information you were receiving about the enforcement action at the Ambassador Bridge on February 12th and 13th, was that mostly from, say, television or news reports?
It was information we received around the cabinet table. often through the RCMP commissioner, or I believe it's also possible through the national security and intelligence apparatus. But I'm pretty sure it was mainly Commissioner Lucky.
Okay, and just to be clear, because I actually don't remember. So February 12th and 13th was a weekend. It was actually Super Bowl weekend. Was there cabinet meetings happening over the course of that weekend?
Yes, there were.
Okay. So I just want to take you, we've looked at a lot of your texts this morning, so I'm just going to bring this particular one up. If we could have SSM CAN 7861. So when you said at 10:30 in the morning that not enough was happening in Windsor, that wasn't based on any situational awareness as the plans were undergoing in Windsor that morning, correct?
Well, it was based on a report that I would have gotten from Minister Mendocino, saying that although the bridge had been cleared, traffic hadn't been, it wasn't yet open to traffic at the time I was texting.
Okay, thank you. Those are my questions.
Thank you. Next call on the government of Saskatchewan, please.
Good afternoon, sir.
Good afternoon.
I am Mitch McAdam, one of the lawyers for the government of Saskatchewan. And I want to ask you a few questions about something that you said during your interview with Commission Counsel. So I would ask the clerk to please pull up the interview summary. It's WTS 6077. And if we could go to the top of page 5, please. Sir, in the second paragraph from the top of that page, you referred to the non-use of provincial legislation by provincial governments as being a factor that informed Cabinet's decision to invoke the Emergencies Act. My question is, were you referring to Ontario's delays in declaring a provincial emergency under their Emergency Management and Civil Protection Act?
In part, I was also referring to inconsistency. For example, applying insurance measures across the country. That's one of the reasons why we invoked the Emergencies Act, in order to get to that particular solution.
Okay. Sir, were you also referring to the fact that laws like Ottawa city bylaws or Ontario's highway traffic laws were not being enforced in downtown Ottawa?
Well, certainly a number of people felt in the public space that ticketing wasn't happening, for example, when it could have been happening. Rigs could have been ticketed, as an example. So yes, that's possible.
Okay, so that possibly was a factor that was being taken into account.
Well, it's certainly something that I took into account.
Okay, thank you, sir. And we've heard a lot of evidence at this commission about various reasons why laws aren't enforced, such as the safety of police officers and the public, the lack of resources, the lack of plans. So you're aware that there could be very good reasons why provincial laws are not being enforced?
Certainly possible.
Okay. And we've also heard this morning in your testimony about what's been called the separation of church and state, and the fact that governments, whether they're municipal, provincial, or federal, don't interfere with the operational decisions of police. Do you recall that?
Very well.
Okay. I believe we're having a fire alarm in our building, but I'm just going to plow ahead and continue. I'm not sure if you can hear the beeping in the background. I'm curious, Minister, how does the federal government assess whether the non-use of provincial legislation warrants invoking the Emergencies Act? You're reviewing the operational decisions of police, aren't you?
Not at all. What we're doing is we're assessing facts on the ground in order to determine whether there is a national emergency, and whether, according to the Emergencies Act, provincial laws are adequate to the task. That includes whether there are gaps in provincial laws or whether there is a necessary or whether there is a non-application of laws. I mean, I could give you examples, but it's your time. So it's really just an assessment of the adequacy of the current state of laws, both in terms of their use or their non-use, as a way of determining whether we've met the threshold for the Emergencies Act.
Okay, but you'll agree with me, sir, that it's a very different thing to be identifying gaps in existing laws so that new tools can be provided, as opposed to reviewing how existing tools are being employed. Those are quite different things, aren't they?
Oh yes, they are, and I'm not being judgmental about the non-use. I'm just saying that's a factor. It's a fact on the ground. I'm not being judgmental about the non-use at all.
Okay, and you'll also agree with me, sir, that to the extent it is a provincial decision as opposed to an operational decision by police. So with respect to something like a province's decision to invoke its own emergencies legislation, that's ordinarily a matter that falls within exclusive provincial jurisdiction, correct?
Yes, that's true. But we had a situation, for example, I saw with my own eyes, the license plates of the rigs that were sitting on Wellington Street in Ottawa, and they came from across the country. And in order for a number of the financial measures that we put into place to work, we needed national application. And although a number of those measures fell within provincial jurisdiction, I think it was quite a reasonable observation on our part to have come to the conclusion that not every province would have put these measures into place in order for us to implement these kinds of financial measures. So again, it's a question of efficacy creating a useful tool that will fill a gap. It's not a judgment. It's not a judgment on the operational plans of any province.
Okay. And sir, you also talked about looking at the existence of effective laws and looking for gaps in the laws. And I take it that could be gaps in either federal laws or provincial laws, correct?
That's correct.
Yeah. And you would agree with me again that in the ordinary course, the decision about whether to enact laws to fill gaps in provincial laws is a matter that falls within the exclusive jurisdiction of the provinces, isn't it?
Oh, absolutely. But we're talking about an emergency here, a temporary limited measure with very specific purposes.
Okay, so just so that I'm clear then, it's your position and the federal government's position that when there is a national emergency, the federal government can review what provincial laws exist and how those laws are being applied. And if it thinks it's necessary, can step in and deal with those matters by orders and regulations under the Emergencies Act, even though those matters would ordinarily fall under provincial jurisdiction, correct?
I just want to say when it comes to the position for the purposes of legal argument, that will be the matter of submissions at the end of the case.
And my short answer is no. I don't agree with the way you've characterized it.
Okay, and can you tell me what part of what I've said you disagree with?
I would suggest you read the Emergencies Act, which says to examine the laws that exist and filling gaps in that matter. And that's all I need to say at this stage.
But you would agree with me that under Section 19 of the Emergencies Act, the federal government can make orders and regulations that deal with matters that in ordinary times would come under the exclusive jurisdiction of the provinces, correct?
I think that's fair, but it's not something one does lightly.
Thank you, sir. Those are all of my questions.
Okay, thank you. And good luck with the fire.
I'm hoping it's a false alarm. Thank you.
I hope so.
You'll need to replace your portrait of the sovereign as well.
Yes, I know.
Okay, next is the Government of Canada, please.
Thank you, Commissioner. And I am advised that the minister needs to go and vote by 3:15. I expect to be done well before that, but just so we're all keeping an eye on the
I will
clock.
have questions, and there may be re-examination, so
Yeah.
we're going to have to figure it out, but one step at a time.
Okay, thank you. Let's start with SSM.can.407845. Minister, just to remind you, in a text message to your Chief of Staff on January 30th, which we'll put on the screen to refresh your memory, you raised a question about the Emergencies Act. You see that?
Yes.
And your testimony in response to questions from Commission Counsel was that you're raising it as a matter of prudence. This is the Sunday evening on the first weekend of the protest. Do you start thinking about the Emergencies Act every time there is a protest?
No, but this was quite extraordinary. We'd already seen a weekend and of a blockade, which wasn't going anywhere soon. So this is just prudence on my part.
And on January 30th, you're testifying that it's a matter of prudence. On what date or at what stage did consideration of the Emergencies Act move from a matter of prudence and a mere possibility to a step that was being given serious consideration by Cabinet?
I think towards, as we moved into the sense I got as we moved into the sort of 11th, 12th, 13th of February, it began to be serious. Certainly for me, it was moving into that weekend that it became a serious possibility for me.
Okay, let's go to SSM.can.407851. And this was a text message exchange with Minister Mendicino that you were taken to by Commission Counsel. You'll recall that Mr. Cameron asked you about your first sentence there, you need to get the police to move. The exchange goes on to talk, you say, and the CAF if necessary. Mr. Mendicino writes, how many tanks are you asking for? I just want to ask Anita how many we've got on hand. You respond, I reckon one will do. On February 2nd, or at any other point, were you seriously suggesting that CAF be brought in or that there be tanks brought in to Ottawa to deal with the situation?
No. This exchange is meant to be a joke between two friends. CAF if necessary. The CAF is always the last resort under the National Defence Act, the very last resort, even after the Emergencies Act. So in a sense, the Emergencies Act is the second last resort. And I think it's fair, particularly as we moved along, that the CAF was not an option.
Okay. You recall questions from Mr. Honor on behalf of the Democracy Fund about the timing of revocation. Let's please put up SSM.can.407902. And Minister, he put to you the suggestion that but for some concern about getting ahead of the NDP, your government would have continued the Emergencies Act. Do you recall those questions?
Yeah, I do.
And you mentioned in your evidence that there were other text messages. This is a text message between yourself and Eric Antoine, February 23rd. Who is Mr. Antoine?
No, it's actually between my chief of staff
okay.
And Mr. Antoine. So I didn't write this text, but with my team, I was tracking the numbers. So with my chief of staff and my director of parliamentary affairs.
Sorry, I just want to be clear. Who is Mr. Antoine?
I believe he is the chief of staff to the government leader in the Senate.
Okay, and in his text message, he says on February 23rd, our count as of right before the announcement, that's the announcement of revocation.
That's right.
Was 51 declared yes, 22 declared against, and 18 undecided. Was that the text message you were
That's
referring
correct.
to?
That's correct.
And SSM.can.407903. Just to continue, it just continues where the bottom is that says, yeah, we worked our ass off, but the right and proper thing to do was to revoke as soon as the
emergency was over.
Oh, if you recall it being emergency was over.
Something to that gist, yeah.
Your evidence is that that's the timing that the government chose for revocation, was when the emergency was over.
Very true. We said from the beginning, when the emergency was objectively over, there we are, pretty close, notwithstanding the Senate process. So we said from the beginning we wouldn't leave it in place a minute longer than we had to. That's exactly what we did. We promised, as I said, the NDP that, we promised Canadians that, and that's how we reacted.
Okay, and you testified in response to questions from Commission Counsel and Ms. Johnson for the Coalition of Ottawa Businesses and Residents about some of your own observations and experiences in the city of Ottawa during the protests, during the occupation. You recall that evidence?
I do.
I want to take you to some online incidents that I understand were directed toward you. See in the time available how many I can come to. SSM.can.407896. And this reads, you're the fucking real terrorist, bud. Too bad this wasn't a few decades ago, because you'd already be hanging from a light pole downtown Ottawa for your treasonous crimes against Canadians. And it goes on from there. Is that a direct message that you received over social media after the Government of Canada announced invocation of the Emergencies Act?
Yes, I did.
Okay, let's go to ssm.can.407897. And while we're pulling that up, just to be clear, the Government of Canada did introduce invocation for a vote in the House of Commons.
Yes.
And you spoke to that?
I did.
And we see a photo of you in the Commons. There's a caption, motion for confirmation of the declaration of emergency. And there's a response to that, hashtag assassinate Lametti. And this is another social media message that you became aware of?
That's right.
ssm.can.407899.
I note another person was insulting me in Italian, which is my mother tongue.
This one says, you and your support structure of corrupt officials need to be drug out into the street and stoned. I think that day is coming for you sooner than you think. You also received this message over Instagram around the time that the Emergency Act was invoked?
Yep, sadly I did.
And last one, ssm.can.407900. This is a Facebook message. I won't read it all, but time to die, David Lametti, for peace and security of mankind. There's a line here, your death date is overdue. Udas with bullet to your head, rope around your neck, guts cut open and bled out on the ground. And then it continues from there. Minister Lametti, were all of these threats reported to the RCMP?
I believe they were. My team, both my constituency team, this was my constituency, and my ministerial teams do routinely report any threats I receive.
And I don't think we have to pull it up, but there is an email to that effect, ssm.can.408683. Minister, we'll just go to one last document, ts.nsc.can.001.50183. Minister Lametti, you have been a member of Parliament since 2015, I understand?
That's correct.
And the sorts of threats that we just walked through, there was one more, we don't need to pull it up, but it was a photo of a noose, ssm.can.407898. Have you ever experienced anything like that in your years as an MP prior to the events of January and February 2022?
Not to that degree. I have had threats. I have had threats online. My family has had threats from time to time, and I have reported them from time to time. Often, I think, from an anecdotal perspective, they're often a product of mental illness, and that's a problem we need to fight. But there really was a marked increase in the virulence and the threats, like the threats to kill me. I think are and the manner in which people would like to kill me have been, I think, they've accelerated immensely.
So on the screen, it's an ITAC report of February 22nd, threats to Canadian political figures and government locations in the context of protests and emergency response measures. Could we please go, Mr. Clerk, to page 2? And there's a heading, increased threats to elected officials during protests. And the second paragraph after the redaction observes, there has been a noticeable increase in threatening behavior towards members of Parliament and incidents at constituency offices since the beginning of the protests, including a recent fire believed to be an arson and a few minor physical altercations with staff. This threatening behavior has been primarily focused on vaccine mandates and the government's enacting of the Emergencies Act, and has been directed at members of all political parties. Minister Lametti, is that consistent with your experience?
Very much so. In fact, at the beginning of the occupation, a number of us living full-time or part-time in the Ottawa or Gatineau areas were worried that our addresses were going to be published online.
Thank you. Those are my questions.
Thank you.
Thank you. Okay, any re-examination?
There is, and I will try to get it in before the division bells call the witness to.
Okay, well, somebody will signal when that time comes, I take it? Okay. Go ahead.
Mr. Chairman, one of the parties, in particular the CCF, the Canadian Constitutional Foundation, and a number of parties by implication indirectly raised the point that was before you on Monday when the CSIS panel was up. And so I'm going to ask this witness some questions about the evidence that Mr. Vigneault gave and see if he can help us at all with the basis on which Mr. Vigneault thought that it was appropriate for him to give an opinion to the Prime Minister about invoking the Act, even though he had an opinion as the director of CSIS that the threshold of 2C had not been met. So with that in mind, let me ask you, Minister Lametti, if you followed that either live or in preparing for the hearing, that exchange in which the director of CSIS, Mr. Vigneault, had said in a closed session, which got summarized into an open session, that based on assurances he had received, he thought it was appropriate to give an opinion to the Prime Minister on whether or not the Act should be invoked, independently of his view on the fact that 2C had not been met. Did you follow that issue?
I read the transcript of it.
Thank you. Well, that helps us. When the matter came up, and Mr. Clerk, are you able to pull up the transcript of the 21st for us, just in case Minister Lametti wants to see the way that Director Vigneault put it? And I'm looking at page 58 of the transcript. Let me, while it's coming up on the screen, Minister Lametti, you've read the transcript, but just to put some context around the question, I'll ask you about it. I'm at the top of page 58 of the transcript, and oh, it looks like we might get it up. 58? And yes, if you could just zoom in so we can get that so when, okay. And this is Director Vigneault speaking. So when that was first brought up, the fact that the Emergencies Act was using the same words as the CSIS Act to define the threat, so imported into the Emergencies Act, I needed to understand for myself and for, the course of this, what the implication of that. And that's when I was assured that, it was a separate understanding. The confines of the CSIS Act and the same words based on legal interpretation, jurisprudence, federal court rulings, and so on. There was a very clear understanding of what those words meant in the confines of the CSIS Act. And what I was reassured by is that there was, in the context of the Emergencies Act, there was to be a separate interpretation based on the confines of that act. And so my question to you, Minister Lametti, is what assurances had Mr. Vigneault received that allowed him to come to that conclusion that there were different interpretations of the test under the CSIS Act and under the Emergencies Act?
Commissioner, I need to object to that question on the grounds that it may get into areas of solicitor-client privilege.
In addition to the fact you're asking me to comment on a conversation to which I was not part of. So.
Commissioner, the Commission Council are in a conundrum here, as I think are the parties who have tried to pursue this issue with Director Vigneault, with Minister Lametti, and with others as the hearing has proceeded. We recognize, though, that solicitor-client privilege poses a special challenge for the Commission, not only because of issues of the extent to which you're able to adjudicate on those issues, but also because the time it takes to resolve them, especially if the matter ends up getting referred to a court of superior jurisdiction, would be frankly fatal to the timetable that you're obliged to work by. And so Commission Council are not going to call on you to make a ruling on this issue. We would observe that we have throughout, that is from the beginning of this proceeding through till now, attempted to find a way to lift the veil that has made such a black box of what has turned out to be a central issue before the hearing. Now, if we believed that that prevented you from assessing the basis on which the government came to its conclusion, we would ask you for a ruling on it, but we are confident that there are other ways that we can get the same information on the record or get the same result through legal arguments, and so we're not pressing you for an issue. We just regret that it ends up being an absence of transparency on the part of the government in this proceeding.
Mr. Commissioner, I apologize for interrupting, but the minister does need to go and vote now. I understand. Perhaps my friend and we can continue to deal with this issue in his absence.
Okay, well, maybe go and vote then, and vote wisely. So
I'll take that. Thank you.
I will adjourn until, I guess, about 10 minutes is.
The commission is in recess for 10 minutes. La commission est levée pour 10 minutes. Order allowed. The commission is reconvened. La commission reprend.
Okay, I understand it's now my turn. Okay. I don't have many questions, so I apologize for making you bounce back and forth. I just want to start with one easy one, which is in one of the cross-examinations, you talked about the insurance and the need to make it national. And I take it you would agree that by the exercise you went through, you're overriding a provincial right, if you like, to control insurance, at least in that limited respect.
That's correct, yes.
So it's an exercise when we look at it, it's not just a sort of a a power of the federal government that's exercised within its discretion. It becomes in a way, a constitutional exercise. It goes into another area of constitutional jurisdiction, and that may have some impact on how this has to be looked at. Would that be fair?
I think that's fair. In response, I guess I would say that it is an emergency, that this is an extraordinary set of powers, which requires an extraordinary set of steps, both before and after.
Yeah, I'm more thinking in terms of the review test.
That's right.
To give you a bit of a hint at what it was. And as a spoiler, I don't think Madame Drouin agreed with you, but that's okay, I gather. The second thing I wanted to just raise quickly, which was also raised, is the role of injunctions. And as I understand it, I may be wrong, you're not a big fan of injunctions being taken by the government.
Well, I think that's generally fair in the sense that I've always felt that governments had other tools at their disposal. That being said, I did join as Attorney General the injunction in the City of Ottawa in order to give complete coverage, territorial coverage, to the citizens seeking the citizens groups seeking injunctive relief, because some of that would have been federal land. So I wanted to make sure that they had complete coverage. I guess it's an old private lawyer's bias that I see injunctions as a private law remedy for citizens to use. In the courts, it is a public law setting, I understand that, but it is a remedy that citizens can use. And I think government has other tools.
And I appreciate that. And
we did talk about it.
And there is also an issue about enforceability and so on. But I guess one of the areas that has come up in the course of these hearings is that law enforcement and sometimes has issues in terms of clarity. And an injunction gives them clarity as to what's legal and what is not. And do you see a role in this type of a protest for injunctions to give police a clear line when it goes from protest to, as you've described it, an occupation?
Fair point. It worked, I suppose, or had a positive role in Windsor. The question of who seeks injunctions, again, it's not necessarily in the toolkit of the federal government if it's not on land that falls within federal jurisdiction, or if the police of jurisdiction doesn't fall within federal authority. But it's definitely there as an option.
Okay, and I'm going to go back to the decision to sort of what we call the church and state distinction and Ipperwash. And I guess one of the things that may or may not be an issue in what we're doing is understanding how Ipperwash would extend to the types of situations that you and your government were faced with. And to put it in an unreasonable way, but as I understand it, the RCMP, the decision to deploy RCMP officers to do provincial, to support the province would not be something that is the province has a right to call on.
It depends on the nature of their agreement with the federal government and the RCMP. Some provinces have contractual policing and don't, but yes, it would be something that they would request of the government or the RCMP, the federal government.
Yeah, and I guess what I'm wondering is is that something that should be reviewed or should be structured in the sense that what is the role of different police and how are they dispatched? In other words, is that purely a decision, and I don't know, by your commissioner to decide to support, for example, the Windsor Police, where there's no agreement and it would be deploying resources and money?
I think the question is probably best asked to Minister Mendicino in the sense that I believe there are agreements in place for the RCMP to move its effective resources around. And I know that's true in provinces where they have contractual policing arrangements. The relationship in Ontario or Quebec, for that matter, where you have multiple levels of policing, including provincial police forces, I think would be different, but I can't say I know the answer to that.
Yeah, because Minister Mendocino did speak about the arrangements, and he did say the political level, he is involved in a decision to deploy from one province to the other, as I understand it. It's actually, as I understand it, a joint decision by the province and the government.
I would take his word for it.
But I neglected to ask him about how it would work in Ontario and whether there's any advantage in that being looked into.
It's a question that we can answer for you, sir. I can't answer the question offhand.
Okay, and just on one final, and I may get into trouble here, so it's your counsel can wade in if need be, but I'm just trying to understand the job that the commission is to do is to look at the decision by cabinet, and as was mentioned by commission counsel, there's an issue of the reasonableness of it. And I'm having a little trouble, and I don't know if you can help me, how we assess reasonableness when we don't know what they were acting on. And do we just presume they were acting in good faith without knowing the basis or structure within which they'd made that decision? And you know of what I speak, I think.
Yeah. I mean, I think we have done our best to provide all the information we can. The Section 58 report effectively gives you the conclusions that we got to.
Yeah.
And the various factors identified in there, facts on the ground, as well as the testimony that you've received from my colleagues, but also including me and other officials, gives you a picture of the actual events that were causing us to move in the direction that we did. You've had some, through testimony, some indication of what the views of the legal standards were, and I'm hoping that our lawyers will make the legal argument to you in their final submissions about the legal basis for what we did. I would expect them to do that, and I'm hoping that will give you a complete picture. I've said this a number of times, but I do think we in an unprecedented circumstance made a reasonable series of decisions. We went through the various possibilities throughout. That's not something we touched in testimony today, but I know my colleagues have, looking at alternatives and trying to figure out what we could do as the federal government in these circumstances. And I do hope we've given the picture. It's awkward for me as Attorney General to be here as Attorney General. It would have been easier just to come as the Minister of Justice, but that is what it is. And it's awkward to have the legal arguments at the end, I suppose.
Yeah, I guess, and I don't mean it in any sort of derogatory or negative way, but the final arguments as to the law are obviously important as to whether or not what was done was met the requirements of the law. I have no trouble with that because that's something that has to be decided. But what I don't know, and I'm not saying we necessarily need to know, is what was the belief of those who made the decision as to what the law was. And I guess the answer is we just assume they acted in good faith in application of whatever they were told. Is that sort of what you're saying?
I think that's fair.
Okay, because I think you understand what I'm saying, and I'm just trying to figure out how I get from A to B, because I'm close to starting to do that.
I understand.
Okay, those are my questions. Thank you very much. And sorry you had to bounce in and out.
That's fine.
but it's good of you to come.
Merci et bonne chance.
Merci beaucoup et bonne chance à vous. Eh? So I'm not sure how it's going to work, but someone will tell me when someone is available. Yeah. So do we start now or? Okay, well, we'll take 5 minutes to sort it.
The commission is in recess for 5 minutes. La commission est levée pour 5 minutes.